Due process, radio station. No. 14, in the morning of August 28, 1987, during the height of the fighting at Channel 4 and Camelot Hotel, the military closed radio station XX, which was excitedly reporting the successes of the rebels and movements towards Manila and troops friendly to the rebels. The reports were correct and factual. On October 6, 1987, after normalcy had returned and the government had full control of the situation, the National Telecommunications Commission, without notice and hearing, but merely on the basis of the report of the military, cancelled the franchise of Station XX. Discuss the legality of the cancellation of the franchise of the station on October 6, 1987. Suggested answer. The cancellation of the franchise of the station on October 6, 1987, without prior notice and hearing, is void. As held in Eastern Broadcasting Corp. v. Dans. 137 SCRA 647, the cardinal primary requirements in administrative proceedings as laid down in Ang Tiba EV. CIR 69 Philosophy 635 must be observed in closing a radio station because radio broadcasts are a form of constitutionally protected expression. Due process, represented by a non-lawyer. Number 5, Norberto Mela SMAs was accused of estafa before the Regional Trial Court of Manila. After the trial, he was found guilty. On appeal, his conviction was affirmed by the Court of Appeals. After the records of his case had been remanded to the Regional Trial Court for execution, and after the latter court had set the date for the promulgation of judgment, the accused filed a motion with the Court of Appeals to set aside the entry of judgment, and to remand the case to the Regional Trial Court for new trial on the ground that he had just discovered that attorney Leonilo Maporma, whom he had chosen and who had acted as his counsel before the trial court and the Court of Appeals, is not a lawyer. Resolved the motion of the accused with reasons. Suggested answer. The motion should be granted and the entry of judgment should be set aside. An accused is entitled to be heard by himself or counsel. Art. 3, SEC 14. Unless he is represented by an attorney, there is a great danger that any defense presented in his behalf will be inadequate considering the legal requisite and skill needed in court proceedings. There would certainly be a denial of due process. Due process, substantive. 2003 No. 12, the Municipal Council of the Municipality of Guigua, Pampanga, passed an ordinance penalizing any person or entity engaged in the business of selling tickets to movies or other public exhibitions, games or performances which would charge children between 7 and 12 years of age the full price of admission tickets instead of only one-half of the amount thereof. Would you hold the ordinance a valid exercise of legislative power by the municipality? Why? Suggested answer. The ordinance is void. As held in Balacuit v. Court of First Instance of Agasan del Norte. 163 SCRA 182, the ordinance is unreasonable. It deprives the sellers of the tickets of their property without due process. A ticket is a property right and may be sold for such price as the owner of it can obtain. There is nothing pernicious in charging children the same price as adults. Due process, suspension of driver's license. No. 3. Congress is considering a law against drunken driving. Under the legislation, police authorities may ask any driver to take a breathalyzer test, wherein the driver exhales several times into a device which determine whether he has been driving under the influence of alcohol. The results of the test can be used in any legal proceeding against him. Furthermore, declaring that the issuance of a driver's license gives rise only to a privilege to drive motor vehicles on public roads. The law provides that a driver who refuses to take the test shall be automatically subject to a 90-day suspension of his driver's license. Cite 2 possible constitutional objections to this law. Resolve the objections and explain whether any such infirmities can be cured. Suggested answer. Possible objections to the law are that requiring a driver to take the breathalyzer test will violate his right against self-incrimination, that providing for the suspension of his driver's license without any hearing violates due process, and that the proposed law will violate the right against unreasonable searches and seizures, because it allows police authorities to require a driver to take the breathalyzer test even if there is no probable cause. Alternative answer. Requiring a driver to take a breathalyzer test does not violate his right against self-incrimination, because he is not being compelled to give testimonial evidence. He is merely being asked to submit to a physical test. This is not covered by the constitutional guarantee against self-incrimination. Thus, in South Dakota vs. Neville, 459 U.S. 553, it was held for this reason that requiring a driver to take a blood alcohol test is valid. As held in McKee vs. Afantria 443 U.S. 1, because of compelling government interest in safety along the streets, the license of a driver who refuses to take the breathalyzer test may be suspended immediately pending a post-suspension hearing. But there must be a provision for a post-suspension hearing. Thus, to save the proposed law from unconstitutionally on the ground of denial of due process, it should provide for an immediate hearing upon suspension of the driver's license. The proposed law violates the right against unreasonable searches and seizures. It will authorize police authorities to stop any driver and ask him to take the breathalyzer test even in the absence of a probable cause. Due process, urgent public need. No. 2. The Manila Transportation Company applied for upward adjustment of its rates before the Transportation Regulatory Board. Pending the petition, the TRB, without previous hearing, granted a general nationwide provisional increase of rates. In another order, TRB required the company to pay the unpaid supervisory fees collectible under the Public Service Law. After due notice and hearing, on the basis of the evidence presented by Manila Transportation Company and the oppositors, TRB issued an order reducing the rates applied for by 1/4. Characterize the powers exercised by the TRB in this case and determine whether under the present constitutional system the Transportation Regulatory Board can be validly conferred the powers exercised by it in issuing the orders given above. Explain. Suggested answer. The orders in this case involve the exercise of judicial function by an administrative agency, and therefore, as a general rule, the cardinal primary rights enumerated in Ang Tiba EV. CIR, 69 Phil. 635 must be observed. In Vigart. Electric Lights VPSC, 10 SCRA 46. It was held that a rate order, which applies exclusively to a particular party and is predicated on a finding of fact, partakes of the nature of a quasi-judicial, rather than legislative, function. The first order, granting a provisional rate increase without hearing, is valid if justified by urgent public need, such as increase in the cost of fuel. The power of the Public Service Commission to grant such increase was upheld in several cases. Silva v. Ocampo, 90 Philosophy 777. Halili v. PSC, 92 Philosophy 1036. The second order requiring the company to pay unpaid supervisory fees under the Public Service Act cannot be sustained. The company has a right to be heard, before it may be ordered to pay. Ang Tiba EVCIR, 69 Phil. 635, the third order can be justified. The fact that the TRB has allowed a provisional rate increase does not bind it to make the order permanent if the evidence submitted does not justify increase but, on the contrary, warrants the reduction of rates. Eminent domain, garnishment. Number 14, the municipality of Antipolo, Rizal, expropriated the property of Juan Reyes for use as a public market. The Municipal Council appropriated PL 000,000.00 for the purchase of the lot, but the Regional Trial Court, on the basis of the evidence, fixed the value at P2,000,000.00. 1. What legal action can Juan Reyes take to collect the balance? 2. Can Juan Reyes ask the Regional Trial Court to garnish the municipality's account with the land bank? Suggested answer, 1. To collect the balance of judgment, as stated in Tan Toco vs Municipal Council of Iloilo, 49 Phil. 52. Juan Reyes may levy on patrimonial properties of the municipality of Antipolo. If it has no patrimonial properties, in accordance with the municipality of Makati vs. Court of Appeals, 190 SCRA 206, the remedy of Juan Reyes is to file a petition for mandamus to compel the municipality of Antipolo to appropriate the necessary funds to satisfy the judgment. 2. Pursuant to the ruling in Pasay City Government vs. Court of First Instance of Manila, 132 SCRA 156, since the municipality of Antipolo has appropriated P1,000,000 to pay for the lot, its bank account may be garnished but up to this amount only. Eminent domain, garnishment. No. 6. 2. If the city of Cebu has money in bank, can it be garnished? Suggested answer, 2. No. The money of the city of Cebu in the bank cannot be garnished if it came from public funds. As held in Municipality of Makati vs. Court of Appeals, 190 SCRA 206, 212, public funds are exempted from garnishment. Eminent domain, immunity from suit. No. 3. The Republic of the Philippines, through the Department of Public Works and Highways, constructed a new highway linking Metro Manila and Quezon Province, and which major thoroughfare traversed the land owned by Mang Pandoy. The government neither filed any expropriation proceedings nor paid any compensation to Mang Pandoy for the land thus taken and used as a public road. Mang Pandoy filed a suit against the government to compel payment for the value of his land. The DPWH filed a motion to dismiss the case on the ground that the state is immune from suit. Mang Pandoy filed an opposition. Resolve the motion. Suggested answer, the motion to dismiss should be denied. As held in Amigable v. Cuenca, 43 SCRA 300, when the government expropriates private property without paying compensation, it is deemed to have waived its immunity from suit. Otherwise, the constitutional guarantee that private property shall not be taken for public use without payment of just compensation will be rendered nugatory. Eminent domain, indirect public benefit. Number 2. The city of Cebu passed an ordinance proclaiming the expropriation of a 10-hectare property of C Company, which property is already a developed commercial center. The city proposed to operate the commercial center in order to finance a housing project for city employees in the vacant portion of the said property. The ordinance fixed the price of the land and the value of the improvements to be paid C Company on the basis of the prevailing land value and cost of construction. As counsel for C Company, give 2 constitutional objections to the validity of the ordinance. As counsel for C Company, I argue that the taking of the property is not for a public use and that the ordinance cannot fix the compensation to be paid C Company, because this is a judicial question that is for the courts to decide. As judge, I will sustain the contention that the taking of the property of C Company to operate the commercial center established within it to finance a housing project for city employees is not for a public use but for a private purpose. As the court indicated in a dictum in Manatok v. National Housing Authority, 150 SCRA 89, that the expropriation of a commercial center so that the profits derived from its operation can be used for housing projects is a taking for a private purpose. I will also sustain the contention that the ordinance, even though it fixes the compensation for the land on the basis of the prevailing land value, cannot really displace judicial determination of the price for the simple reason that many factors, some of them supervening, cannot possibly be considered by the legislature at the time of enacting the ordinance. There is greater reason for nullifying the use of the cost of construction in the ordinance as basis for compensation for the improvements. The fair market value of the improvements may not be equal to the cost of construction. The original cost of construction may be lower than the fair market value, since the cost of construction at the time of expropriation may have increased. Alternative answer. The taking of the commercial center is justified by the concept of indirect public benefit since its operation is intended for the development of the vacant portion for socialized housing, which is clearly a public purpose. Eminent domain, just compensation. Number 8. Mr. Roland Rivera is the owner of 4 lots sought to be expropriated by the Export Processing Zone Authority for the expansion of the Export Processing Zone at Baguio City. The same parcels of land had been valued by the assessor at P120,000 per square meter, while Mr. Rivera had previously fixed the market value of the same at P100 per square meter. The regional trial court decided for expropriation and ordered the payment to Mr. Rivera at the rate of P100 a square meter. Pursuant to Presidential Decree No. 1533, providing that in determining just compensation for private property acquired through eminent domain proceedings, the compensation to be paid shall not exceed the value declared by the owner or determined by the assessor. Pursuant to the Real Property Tax Code, whichever value is lower, prior to the recommendation or decision of the appropriate government office to acquire the property. Mr. Rivera appealed, insisting that just compensation for his property should be determined by commissioners who could evaluate all evidence on the real value of the property, at the time of its taking by the government. He maintains that the lower court erred in relying on Presidential Decree No. 1533, which he claims is unconstitutional. How would you decide the appeal? Explain your answer. Suggested answer. The decision of the lower court should be reversed. In EPZAV, Dule, 149 SCRA 305, the Supreme Court declared PD No. 1533 to be an unconstitutional encroachment on the prerogatives of the judiciary. It was explained that although a court would technically have the power to determine the just compensation for property under the decree, the court's task would be relegated to simply stating the lower value of the property as declared either by the owner or by the assessor. Just compensation means the value of the property at the time of the taking. It means a fair and full equivalent for the loss sustained. To determine it requires consideration of the condition of the property and its surrounding, its improvements and capabilities. Eminent domain, just compensation. No. 6. A law provides that in the event of expropriation, the amount to be paid to a landowner as compensation shall be either the sworn valuation made by the owner or the official assessment thereof, whichever is lower. Can the landowner successfully challenge the law in court? Discuss briefly your answer. Suggested answer. Yes, the landowner can successfully challenge the law in court. According to the decision in Export Processing Zone Authority vs. Dule, 149 SCRA 305, such a law is unconstitutional. First of all, it violates due process, because it denies to the landowner the opportunity to prove that the valuation in the tax declaration is wrong. Secondly, the determination of just compensation in expropriation cases is a judicial function. Since under Section Article 3 of the 1987 Constitution, private property shall not be taken for public use without just compensation, no law can mandate that its determination as to the just compensation shall prevail over the findings of the court. Eminent domain, just compensation. No. 6. The city of Cebu expropriated the property of Carlos Tapico for use as a municipal parking lot. The Sangguniang Panlungsod appropriated P10 million for this purpose, but the regional trial court fixed the compensation for the taking of the land at P15 million. 1. What legal remedy, if any, does Carlos Tapico have to recover the balance of P5 million for the taking of his land? Suggested answer. 1. The remedy of Carlos Tapico is to levy on the patrimonial properties of the city of Cebu. In Municipality of Bao Avs Manaois, 86 Phil 629. 632, the Supreme Court held, property, however, which is patrimonial and which is held by a municipality in its proprietary capacity is treated by the great weight of authority as the private asset of the town and may be levied upon and sold under an ordinary execution. If the city of Cebu does not have patrimonial properties, the remedy of Carlos Tapico is to file a petition for mandamus to compel it to appropriate money to satisfy the judgment. In Municipality Makati vs Court of Appeals, 190 SCRA 206, 213. The Supreme Court said, where a municipality falls or refuses, without justifiable reason, to effect payment of a final money judgment rendered against it, the claimant may avail of the remedy of mandamus in order to compel the enactment and approval of the necessary appropriation ordinance, and the corresponding disbursement of municipal funds therefore. Alternative answer. 1. He can file the money claim with the Commission on Audit. Eminent domain, legal interest. No. 5. In expropriation proceedings, 1. What legal interest should be used in the computation of interest on just compensation? Suggested answer. As held in National Power Corporation vs Ongas. 208 SCRA 542, in accordance with Article 2209 of the Civil Code, the legal interest should be 6% a year. Central Bank Circular Number 416, which increased the legal interest to 12% a year, is not applicable to the expropriation of property and is limited to loans, since its issuance is based on Presidential Decree No. 116, which amended the usury law. Eminent domain, non-observance of the policy of all or none. No. 8. Madlang Bayan is the owner of a 500 square meter lot which was the birthplace of the founder of a religious sect who admittedly played an important role in Philippine history and culture. The National Historical Commission passed a resolution declaring it a national landmark, and on its recommendation the lot was subjected to expropriation proceedings. This was opposed by Madlang Bayan on the following grounds: a. That the lot is not a vast tract, b. That those to be benefited by the expropriation would only be the members of the religious sect of its founder, and c. That the NHC has not initiated the expropriation of birthplaces of other more deserving historical personalities. Resolve the opposition raised by Madlang Bayan. Suggested answer. The arguments of Madlang Bayan are not meritorious. According to Manasksa v Court of Appeals, 252 SCRA 412, the power of eminent domain is not confined to expropriation of vast tracts of the land. The expropriation of the lot to preserve it as the birthplace of the founder of the religious sect because of his role in Philippine history and culture is for a public purpose. Because public use is no longer restricted to the traditional concept, the fact that the expropriation will benefit the members of the religious sect is merely incidental. The fact that other birthplaces have not been expropriated is likewise not a valid basis for opposing the expropriation. As held in J.M. Tuason and Company, Inc. v. Land Tenure Administration, 31 SCRA 413, the expropriating authority is not required to adhere to the policy of all or none. Eminent domain, power to exercise. The Sangguniang Bayan of the Municipality of Santa Ilocos Sur passed Resolution No. 1 authorizing its mayor to initiate a petition for the expropriation of a lot owned by Cristina as site for its municipal sports center. This was approved by the mayor. However, the Sangguniang Panlalawigan of Ilocos Sur disapproved the resolution as there might still. Nonetheless, the municipality of Santa, through its mayor, filed a complaint for eminent domain. Cristina opposed this on the following grounds. 1. The municipality of Santa has no power to expropriate. 2. Resolution No. 1 has been voided since the Sangguniang Panlalawigan disapproved it for being arbitrary. And 3. The municipality of Santa has other and better lots for that purpose. Resolve the case with reasons. Suggested answers. A. Under Section 19 of R. A. Number 7160, the power of eminent domain is explicitly granted to the municipality, but must be exercised through an ordinance rather than through a resolution. B. The Sangguniang Panlalawigan of Ilocos Sur was without the authority to disapprove Resolution No. 1 as the municipality clearly has the power to exercise the right of eminent domain and its Sangguniang Bayan the capacity to promulgate said resolution. The only ground upon which a provincial board may declare any municipal resolution, ordinance, or order invalid is when such resolution, ordinance or order is beyond the powers conferred upon the council or president making the same. Such is not the situation in this case. C. The question of whether there is genuine necessity for the expropriation of Cristina's lot or whether the municipality has other and better lots for the purpose is a matter that will have to be resolved by the court upon presentation of evidence by the parties to the case. Eminent domain, public use. No. 16, in January 1984. Pasay City filed expropriation proceedings against several landowners for the construction of an aqueduct for flood control in a barangay. Clearly, only the residents of that barangay would be benefited by the project. As compensation, the city offered to pay only the amount declared by the owners in their tax declarations, which amount was lower than the assessed value as determined by the assessor. The landowners oppose the expropriation on the grounds that the same is not for public use, and assuming it is for public use, the compensation must be based on the evidence presented in court and not as provided in presidential decrees prescribing payment of the value stated in the owner's tax declarations or the value determined by the assessor, whichever is lower. Suggested answer. If you were judge, how would you rule on the issue? Why? Suggested answer. The contention that the taking of private property for the purpose of constructing an aqueduct for flood control is not for public use is untenable. The idea that public use means exclusively use by the public has been discarded. As long as the purpose of the taking is public, the exercise of power of eminent domain is justifiable. Whatever may be beneficially employed for the general welfare satisfies the requirement of public use. But the contention that the presidential decrees providing that in determining just compensation the value stated by the owner in his tax declaration or that determined by the assessor, whichever is lower, in unconstitutional is correct. In EPZAV Dule. GR number 59603, April 29, 1987, it was held that this method prescribed ascertaining just compensation constitutes an impermissible encroachment on the prerogatives of courts. It tends to render courts inutile in a matter which, under the Constitution, is reserved to them for final determination. For although under the decrees the courts still have to determine just compensation, their task is reduced to simply determining the lower value of the property as declared either by the owner or by the assessor. Just compensation means the value of the property at the time of the taking. Its determination requires that all facts as to the condition of the property and its surroundings and its improvements and capabilities must be considered, and this can only be done in a judicial proceeding. Eminent domain, socialized housing. Number 4. The city of Pasig initiated expropriation proceedings on a 1-hectare lot which is part of a 10-hectare parcel of land devoted to the growing of vegetables. The purpose of the expropriation is to use the land as a relocation site for 200 families squatting along the Pasig River. A. Can the owner of the property oppose the expropriation on the ground that only 200 out of the more than 10,000 squatter families in Pasig City will benefit from the expropriation? Explain. B. Can the Department of Agrarian Reform require the city of Pasig to first secure authority from said department before converting the use of the land from agricultural to housing? Explain. Suggested answer: A. No. The owner of the property cannot oppose the expropriation on the ground that only 200 out of more than 10,000 squatter families in Pasig City will benefit from the expropriation. As held in Philippine-Colombian Association vs. Pants, 228 SCRA 668, the acquisition of private property for socialized housing is for public use, and the fact that only a few and not everyone will benefit from the expropriation does not detract from the nature of the public use. B. No. The Department of Agrarian Reform cannot require Pasig City to first secure authority from it before converting the use of the land from agricultural to residential. According to Province of Camarines Sur vs Court of Appeals, 222 SCRA 173. There is no provision in the Comprehensive Agrarian Reform Law which subjects the expropriation of agricultural lands by local government units to the control of the Department of Agrarian Reform and to require approval from the Department of Agrarian Reform will mean that it is not the local government unit but the Department of Agrarian Reform who will determine whether or not the expropriation is for a public use. Eminent domain, writ of possession. No. 5. In expropriation proceedings, can the judge validly withhold issuance of the writ of possession until full payment of the final value of the expropriated property? No. The judge cannot validly withhold the issuance of the writ of possession until full payment of the final value of the expropriated property. As held in National Power Corporation vs Jaclyn, 206 SCRA 520. It is the ministerial duty of the judge to issue the writ of possession upon deposit of the provisional value of the expropriated property with the national or provincial treasurer. Alternative answer. In Republic vs Jinjoyan, GR No. 166,429, December 19, 2005, the SC held that RA 8974 now requires full payment before the state may exercise proprietary rights in an expropriation proceeding and making the previous ruling obiter dictum. Equal protection, alien employment. Number 18. An ordinance of the City of Manila requires every alien desiring to obtain employment of whatever kind, including casual and part-time employment, in the city to secure an employment permit from the city mayor and to pay a work permit fee of P500. Is the ordinance valid? Suggested answer. No, the ordinance is not valid. In Villegas vs Hiu Chiang Sai Pao Ho, 86 SCRA 270, it was held that such an ordinance violates equal protection. It failed to consider the valid substantial differences among the aliens required to pay the fee. The same among it being collected from every employed alien, whether he is casual or permanent, part-time or full-time. The ordinance also violates due process, because it does not contain any standard to guide the mayor in the exercise of the power granted to him by the ordinance. Thus, it confers upon him unrestricted power to allow or prevent an activity which is lawful per se. Equal protection, invidious discrimination. No. 6, Marina Neptunia, daughter of a sea captain and sister to 4 marine officers, decided as a child to follow in her father's footsteps. In her growing up years she was as much at home on board a boat as she was in the family home by the sea. In time she earned a Bachelor of Science degree in Marine Transportation, major in Navigation and Seamanship. She served her apprenticeship for a year in a merchant marine vessel registered for foreign trade and another year on a merchant marine vessel registered for coastwise trade. But to become a full-fledged marine officer she had to pass the appropriate board examinations before she could get her professional license and registration. She applied in January 1986 to take examination for marine officers, but her application was rejected for the reason that the law regulating the practice of marine profession in the Philippines. Press. Dis number 97, specifically prescribes that no person shall be qualified for examination as marine officer unless he is. Marina feels very aggrieved over the denial and has come to you for advice. She wants to know whether the Board of Examiners had any plausible or legal basis for rejecting her application in 1986. Explain briefly whether the 1987 Constitution guarantees her the right to admission to take the coming January 1988 Marine Officers examinations. Explain and cite relevant provisions. Suggested answer. The disqualification of females from the practice of marine profession constitutes as invidious discrimination condemned by the Equal Protection Clause of that Constitution, Art. 4, seconds. In the United States, under a similar provision, while earlier decisions of the Supreme Court upheld the validity of a statute prohibiting women from bartending unless she was the wife or daughter of a male owner, Goissert v. Cleary, 335 U.S. 464. And denying to women the right to practice law. Bradwell v. State, 83 U.S. 130. Recent decisions have invalidated statutes or regulations providing for differential treatment of females based on nothing stereotypical and inaccurate generalizations. The court held that classification based on sex, like classifications based upon race, alienage, or national origin, are inherently suspect, and must therefore be subjected to strict judicial scrutiny. Accordingly, the court invalidated a statute permitting a male serviceman to claim his spouse as a dependent to obtain increased quarter allowance, regardless of whether the wife is actually dependent on him, while denying the same right to a servicewoman unless her husband was in fact dependent on her for over one-half of his support. Frontiero v. Richardson, 411 U.S. 687. Accord Craig v. Boren, 429 U.S. 190. Reed v. Reed, 404 U.S. 71. In addition to the Equal Protection Clause, The 1987 Constitution now requires the state to ensure the fundamental equality before the law of women and men. Art 2, Security. 14. And to provide them with such facilities and opportunities that will enhance their welfare and enable them to realize their full potential in the service of the nation. Art. Sector 14. These provisions put in serious doubt the validity of PD 97 limiting the practice of marine profession to males. Equal protection, invidious discrimination. Number 10, X, a son of a rich family, applied for enrollment with the San Carlos Seminary in Mandaluyong, Metro Manila. Because he had been previously expelled from another seminary for scholastic deficiency, the rector of San Carlos Seminary denied the application without giving any grounds for the denial. After X was refused admission, the rector admitted another applicant, who is the son of a poor farmer who was also academically deficient. Prepare a short argument citing rules, laws, or constitutional provisions in support of X's motion for reconsideration of the denial of his application. Suggested answer: the refusal of the seminary to admit X constitutes invidious discrimination, violative of the Equal Protection Clause of the Constitution. The fact that the other applicant is the son of a poor farmer does not make the discrimination any less invidious, since the other applicant is also academically deficient. The reverse discrimination practiced by the seminary cannot be justified because, unlike the race problem in America, poverty is not a condition of inferiority needing redress. Equal protection, police power. No. 4. Undaunted by his 3 failures in the National Medical Admission Test, Cruz applied to take it again, but he was refused because of an order of the Department of Education, Culture and Sports disallowing flunkers from taking the test a 4th time. Cruz filed suit assailing this rule, raising the constitutional grounds of accessible quality education, academic freedom, and equal protection. The government opposes this, upholding the constitutionality of the rule on the ground of exercise of police power. Decide the case discussing the grounds raised. Suggested answer: as held in Department of Education, Culture, and Sports v. San Diego 180 SCRA 533, the rule is a valid exercise of police power to ensure that those admitted to the medical profession are qualified. The arguments of Cruz are not meritorious. The right to quality education and academic freedom are not absolute. Under Section 5, Article 14 of the Constitution, the right to choose a profession is subject to fair, reasonable, and equitable admission and academic requirements. The rule does not violate equal protection. There is a substantial distinction between medical students and other students. Unlike other equal protection, right to education. Number 12. The Department of Education, Culture, and Sports issued a circular disqualifying anyone who fails for the 4th time in the national entrance tests from admission to a college of dentistry. X, who was thus disqualified, questions the constitutionality of the circular. 1. Did the circular deprive her of her constitutional right to education? 2. Did the circular violate the Equal Protection Clause of the Constitution? Suggested answer: 1. No, because it is a permissive limitation to right to education, as it is intended to ensure that only those who are qualified to be dentists are admitted for enrollment. 2. No, the circular did not violate the Equal Protection Clause of the Constitution. There is a substantial distinction between dentistry students and other students. The dental profession affects the lives and health of people. Other professions do not involve the same delicate responsibility and need not be similarly treated. This is in accordance with the ruling in Department of Education, Culture, and Sports vs. San Diego, 180 SCRA 533. Equal protection, subsidiary imprisonment. Number 4. X was sentenced to a penalty of 1 year and 5 months of prison correctional and to pay a fine of P8,000.00, with subsidiary imprisonment in case of solvency. After serving his prison term, X asked the director of prisons whether he could already be released. X was asked to pay the fine of P5,000.00 and he said he could not afford it, being an indigent. The director informed him he has to serve an additional prison term at the rate of 1 day per 8 pesos in accordance with Article 39 of the revised Penal Code. The lawyer of X filed a petition for habeas corpus contending that the further incarceration of his client for unpaid fines violates the Equal Protection Clause of the Constitution. Decide. Suggested answer. The petition should be granted, because Article 39 of the revised Penal Code is unconstitutional. In Tate vs. Short, 401 U.S. 395, the United States Supreme Court held that imposition of subsidiary imprisonment on a convict who is too poor to pay a fine violates equal protection, because economic status cannot serve as a valid basis for distinguishing the duration of the imprisonment between a convict who is able to pay the fine and a convict who is unable to pay it. On the other hand, in United States ex rel. Privitera vs. Cross, 239 F sup 118, it was held that the imposition of subsidiary imprisonment for inability to pay a fine does not violate equal protection, because the punishment should be tailored to fit the individual. And equal protection does not compel the eradication of every disadvantage caused by indigence. The decision was affirmed by the United States Circuit Court of Appeals in 345 F2D 533, and the United States Supreme Court denied the petition for certiorari in 382 U.S. 911. This ruling was adopted by the Illinois Supreme Court in People v.S. Williams, 31 ALR 3D 920. Freedom of expression, censorship. No. 9. May the Cumlic prohibit the posting of decals and stickers on mobile places, public or private, such as on a private vehicle, and limit their location only to the authorized posting areas that the Cumlic itself fixes. Explain. Suggested answer. According to Adian v. Cumlic, 207 SCRA 712, the prohibition is unconstitutional. It curtails the freedom of expression of individuals who wish to express their preference for a candidate by posting decals and stickers on their cars and to convince others to agree with them. It is also overbroad, because it encompasses private property and constitutes deprivation of property without due process of law. Ownership of property includes the right to use. The prohibition is censorship, which cannot be justified. Freedom of expression, prior restraint. Number 16. The Secretary of Transportation and Communications has warned radio station operators against selling block time, on the claim that the time covered thereby are often used by those buying them to attack the present administration. Assume that the department implements this warning and orders owners and operators of radio stations not to sell block time to interested parties without prior clearance from the Department of Transportation and Communications. You are approached by an interested party affected adversely by that order of the Secretary of Transportation and Communications. What would you do regarding that ban on the sale of block time? Explain your answer. Suggested answer. I would challenge its validity in court on the ground that it constitutes a prior restraint on freedom of expression. Such a limitation is valid only in exceptional cases, such as where the purpose is to prevent actual obstruction to recruitment of service or the sailing dates of transports or the number and location of troops, or for the purpose of enforcing the primary requirements of decency or the security of community life. Near v. Minnesota, 283 U.S. 697. Attacks on the government, on the other hand, cannot justify prior restraints. For as has been pointed out, the interest of society and the maintenance of good government demand a full discussion of public affairs. Complete liberty to comment on the conduct of public men is a scalpel in the case of free speech. The sharp incision of its probe relieves the abscesses of officialdom. Men in public life may suffer under a hostile and an unjust accusation. The wound can be assuaged with the balm of a clear conscience. United States v. Bustos, 37 Phil. 741. The parties adversely affected may also disregard the regulation as being on its face void. As has been held, any system of prior restraints of expression comes to the court bearing a heavy presumption against its constitutional validity, and the government thus carries a heavy burden of showing justification for the imposition of such a restraint. The usual presumption of validity that inheres in legislation is reversed in the case of laws imposing prior restraint on freedom of expression. Freedom of religion, convicted prisoners. Number 5, X is serving his prison sentence in Muntinlupa. He belongs to a religious sect that prohibits the eating of meat. He asked the director of prisons that he be served with meatless diet. The director refused and X sued the director for damages for violating his religious freedom. Decide. Suggested answer. Yes, the director of prison is liable under Article 32 of the Civil Code for violating the religious freedom of X. According to the decision of the United States Supreme Court in the case of Olone vs. Estate of Shabazz, 107 SCT 2400, convicted prisoners retain their right to free exercise of religion. At the same time, lawful incarceration brings about necessary limitations of many privileges and rights justified by the considerations underlying the penal system. In considering the appropriate balance between these two factors, reasonableness should be the test. Accommodation to religious freedom can be made if it will not involve sacrificing the interests of security and it will have no impact on the allocation of the resources of the penitentiary. In this case, providing X with a meatless diet will not create a security problem or unduly increase the cost of food being served to the prisoners. In fact, in the case of Olone vs. Estate of Shabazz, it was noted that the Muslim prisoners were being given a different meal whenever pork would be served. Alternative answer. The suit should be dismissed. The Free Exercise Clause of the Constitution is essentially a restraint on governmental interference with the right of individuals to worship as they please. It is not a mandate to the state to take positive, affirmative action to enable the individual to enjoy his freedom. It would have been different had the director of prisons prohibited meatless diets in the penal institution. Freedom of religion, limitations. No. 15. Our religious organization has a weekly television program. The program presents and propagates its religious doctrines, and compares their practices with those of other religions. As the Movie and Television Review and Classification Board found as offensive several episodes of the program which attacked other religions. The MTRCB required the organization to submit its tapes for review prior to airing. The religious organization brought the case to court on the ground that the action of the MTRCB suppresses its freedom of speech and interferes with its right to free exercise of religion. Decide. Suggested answer. The religious organization cannot invoke freedom of speech and freedom of religion as grounds for refusing to submit the tapes to the Movie and Television Review and Classification Board for review prior to airing. When the religious organization started presenting its program over television, it went into the realm of action. The right to act on one's religious belief is not absolute and is subject to police power for the protection of the general welfare. Hence the tapes may be required to be reviewed prior to airing. In Iglesia ni Cristo vs Court of Appeals, 259 SCRA 529, 544, the Supreme Court held, "We thus reject petitioner's postulate that its religious program is per se beyond review by the respondent board. Its public broadcast on TV of its religious program brings it out of the bosom of internal belief. Television is a medium that reaches even the eyes and ears of children. The court reiterates the rule that the exercise of religion's freedom can be regulated by the state when it will bring about the clear and present danger of some substantive evil which the state is duty-bound to prevent, i.e., serious detriment to the mere overriding interest of public health, public morals, or public welfare. However, the Movie and Television Review and Classification Board cannot ban the tapes on the ground that they attacked other religions." In Iglesia ni Cristo vs Court of Appeals, 259 SCRA 529, 547, the Supreme Court held, "Even a side glance at Section 3 of PD No. 1986 will reveal that it is not among the grounds to justify an order prohibiting the broadcast of petitioner's television program. Moreover, the broadcasts do not give rise to a clear and present danger of a substantive evil." In the case of Iglesia ni Cristo vs Court of Appeals, 259 SCRA 529, 549. Prior restraint on speech, including the religious speech, cannot be justified by hypothetical fears but only by the showing of a substantive and imminent evil which has taken the reality already on the ground. Freedom of religion, flag salute. Number 12, Section 28. Title 6, Chapter 9, of the Administrative Code of 1987 requires all educational institutions to observe a simple and dignified flag ceremony, including the playing or singing of the Philippine national anthem. Pursuant to rules to be promulgated by the Secretary of Education, Culture and Sports, the refusal of a teacher, student, or pupil to attend or participate in the flag ceremony is a ground for dismissal after due investigation. The Secretary of Education, Culture and Sports issued a memorandum implementing said provision of law. As ordered, the flag ceremony would be held on Mondays at 7:30 a.m. during class days. A group of teachers, students, and pupils requested the Secretary that they be exempted from attending the flag ceremony on the ground that attendance thereto was against their religious belief. The Secretary denied the request. The teachers, students, and pupils concerned went to court to have the memorandum circular declared null and void. Decide the case. Suggested answer: the teachers and the students should be exempted from the flag ceremony. As held in Ibrahim ES Division Superintendent of Schools of Cebu, 251 SCRA 569. To compel them to participate in the flag ceremony will violate their freedom of religion. Freedom of religion cannot be impaired except upon the showing of a clear and present danger of a substantive evil which the state has a right to prevent. The refusal of the teachers and the students to participate in the flag ceremony does not pose a clear and present danger. Freedom of religion, flag salute. No. 3. Children who are members of a religious sect have been expelled from their respective public schools for refusing, on account of their religious beliefs, to take part in the flag ceremony, which includes playing by a band or singing the national anthem, saluting the Philippine flag and reciting the patriotic pledge. The students and their parents assail the expulsion on the ground that the school authorities have acted in violation of their right to free public education, freedom of speech, and religious freedom and worship. Decide the case. Suggested answer. The students cannot be expelled from school. Elton E. Berlinig v. The Division Superintendent of Schools of Cebu. 219 SCRA 256, to compel students to take part in the flag ceremony when it is against their religious beliefs will violate their religious freedom. Their expulsion also violates the D of the state under Article 14, Section 1 of the Constitution to protect and promote the right of all citizens to quality education and make such education accessible to all. Freedom of religion, Non-Establishment Clause. Number 7, Taai is a predominantly Muslim province. The governor, the vice-governor, and members of its Sangguniang Panlalawigan are all Muslims. Its budget provides the governor with a certain amount as his discretionary funds. Recently, however, the Sangguniang Panlalawigan passed a resolution appropriating P100,000 as a special discretionary fund of the governor to be spent by him in leading a pilgrimage of his province mates to Mecca, Saudi Arabia, Islam's holiest city. Philconsa, on constitutional grounds, has filed suit to nullify the resolution of the Sangguniang Panlalawigan giving the special discretionary fund to the governor for the stated purpose. How would you decide the case? Give your reasons. Suggested answer. The resolution is unconstitutional. First, it violates Art. 6, Section 29 of the Constitution, which prohibits the appropriation of public money or property, directly or indirectly, for the use, benefit, or support of any system of religion, and, second, it contravenes Art. 6, SEC 25, which limits the appropriation of discretionary funds only for public purposes. The use of discretionary funds for purely religious purpose is thus unconstitutional, and the fact that the disbursement is made by resolution of a local legislative body and not by Congress does not make it any less offensive to the Constitution. Above all, the resolution constitutes a clear violation of the Non-Establishment Clause of the Constitution. Freedom of religion, Non-Establishment Clause. Number 10, recognizing the value of education in making the Philippine labor market attractive to foreign investment, the Department of Education, Culture and Sports offers subsidies to accredited colleges and universities in order to promote quality tertiary education. The DECS grants a subsidy to a Catholic school which requires its students to take at least 3 hours a week of religious instruction. A. Is the subsidy permissible? Explain. B. Presuming that you answer in the negative, would it make a difference if the subsidy were given solely in the form of laboratory equipment in chemistry and physics? C. Presume, on the other hand, that the subsidy is given in the form of scholarship vouchers given directly to the student and which the student can use for paying tuition in any accredited school of his choice, whether religious or non-sectarian. Will your answer be different? Suggested answer. A. No, the subsidy is not permissible. It will foster religion, since the school gives religious instructions to its students. Besides, it will violate the prohibition in Section 29(2)(j), Article 6 of the Constitution against the use of public funds to aid religion. In Lemon vs. Kurtzman, 403 U.S. 602, it was held that financial assistance to a sectarian school violates the prohibition against the establishment of religion if it fosters an excessive government entanglement with religion. Since the school requires its students to take at least 3 hours a week of religious instructions, to ensure that the financial assistance will not be used for religious purposes, the government will have to conduct a continuing surveillance. This involves excessive entanglement with religion. B. If the assistance would be in the form of laboratory equipment in chemistry and physics, it will be valid. The purpose of the assistance is secular, i.e., the improvement of the quality of tertiary education. Any benefit to religion is merely incidental. Since the equipment can only be used for a secular purpose, it is religiously neutral. As held in Tilton vs. Richardson, 403 U.S. 672, it will not involve excessive government entanglement with religion, for the use of the equipment will not require surveillance. C. In general, the giving of scholarship vouchers to students is valid. Section 2, Article 14 of the Constitution requires the state to establish a system of subsidies to deserving students in both public and private schools. However, the law is vague and overbroad. Under it, a student who wants to study for the priesthood can apply for the subsidy and use it for his studies. This will involve using public funds to aid religion. Freedom of religion, non-establishment clause. Number 4. Upon request of a group of overseas contract workers in Brunei, Rev. Father Juan de la Cruz, a Roman Catholic priest, was sent to that country by the President of the Philippines to minister to their spiritual needs. The travel expenses, per diems, clothing allowance, and monthly stipend of P5,000 were ordered charged against the President's discretionary fund. Upon post-audit of the vouchers, therefore, the Commission on Audit refused approval thereof, claiming that the expenditures were in violation of the Constitution. Was the Commission on Audit correct in disallowing the vouchers in question? Suggested answer: yes, the Commission on Audit was correct in disallowing the expenditures. Section 29, Article 6 of the Constitution prohibits the expenditure of public funds for the use, benefit, or support of any priest. The only exception is when the priest is assigned to the armed forces, or to any penal institution or government orphanage or leprosarium. The sending of a priest to minister to the spiritual needs of overseas contract workers does not fall within the scope of any of the exceptions. Freedom of speech, ban on tobacco AD. Number 1. Congress passes a law prohibiting television stations from airing any commercial advertisement which promotes tobacco or in any way glamorizes the consumption of tobacco products. This legislation was passed in response to findings by the Department of Health about the alarming rise in lung diseases in the country. The World Health Organization has also reported that U.S. tobacco companies have shifted marketing efforts to the Third World due to dwindling sales in the health-conscious American market. Cowboy Levi's, a jeans company, recently released an advertisement featuring model Richard Burgos wearing Levi's jackets and jeans and holding a pack of Marlboro cigarettes. The Asian Broadcasting Network, a privately owned television station, refuses to air the advertisement in compliance with the law. A. Assume that such refusal abridges the freedom of speech. Does the constitutional prohibition against the abridgment of the freedom of speech apply to acts done by ABN, a private corporation? Explain. B. May Cowboy Levi's, a private corporation, invoke the free speech guarantee in its favor? Explain. C. Regardless of your answers above, decide the constitutionality of the law in question. Suggested answer: A. The constitutional prohibition against the freedom of speech does not apply to ABN, a private corporation. As stated in Hudgens vs. National Labor Relations Board, 424 U.S. 507, the constitutional guarantee of freedom of speech is a guarantee only against abridgment by the government. It does not therefore apply against private parties. Alternative answer: since ABN has a franchise, it may be considered an agent of the government by complying with the law and refusing to air the advertisement. It aligned itself with the government. Thus it rendered itself liable for lawsuit which is based on abridgment of the freedom of speech. Under Article 32 of the Civil Code, even private parties may be liable for damages for impairment of the freedom of speech. B. Cowboy levies may invoke the constitutional guarantee of freedom of speech in its favor. In First National Bank of Boston vs. Bellotti, 435 U.S. 765, it was ruled that this guarantee extends to corporations. In Virginia State Board of Pharmacy vs. Virginia Citizens Consumer Council Inc., 425 U.S. 748, it was held that this right extends to commercial advertisements. In Air Productions Thai, Ltd vs. Kapulong, 160 SCRA 861, the Supreme Court held that even if the production of a film is a commercial activity that is expected to yield profits, it is covered by the guarantee of freedom of speech. C. The law is constitutional. It is a valid exercise of police power. Freedom of the press, actual malice. The Star, a national daily newspaper, carried an exclusive report stating that Senator X received a house and lot located at YY Street, Makati. In consideration for his vote cutting cigarette taxes by 50%. The senator sued the Star, its reporter, editor, and publisher for libel, claiming the report was completely false and malicious. According to the senator, there is no YY Street in Makati, and the tax cut was only 20%. He claimed 1 million pesos in damages. The defendants denied actual malice, claiming privileged communication and absolute freedom of the press to report on public officials and matters of public concern. If there was any error, the Star said it would publish the correction promptly. Is there actual malice in Star's reportage? How is actual malice defined? Are the defendants liable for damages? First alternative answer. Since Senator XX is a public person and the questioned imputation is directed against him in his public capacity, in this case actual malice means the statement was made with knowledge that it was false or with reckless disregard of whether it was false or not. Borja v. Court of Appeals, 301 SCRA 1/1999. Since there is no proof that the report was published with knowledge that it is false or with reckless disregard of whether it was false or not, the defendants are not liable for damage. Second alternative answer. Since Senator XX is a public person and the questioned imputation is directed against him in his public capacity, in this case actual malice means the statement was made with knowledge that it was false or with reckless disregard of whether it was false or not. Borja v. Court of Appeals, 301 SCRA 1/1999. Since it is a matter of public knowledge that there is no YY Street in Makati, the publication was made with reckless disregard of whether or not it is false. The defendants may be held liable for damages. Freedom of the press, wartime censorship. No. 14, in the morning of August 28, 1987, during the height of the fighting at Channel 4 and Camelot Hotel, the military closed radio station XX, which was excitedly reporting the successes of the rebels and movements towards Manila and troops friendly to the rebels. The reports were correct and factual. On October 6, 1987, after normalcy had returned and the government had full control of the situation, the National Telecommunications Commission, without notice and hearing, but merely on the basis of the report of the military, cancelled the franchise of Station XX. Discuss the legality of the action taken against the station on August 28, 1987, the cancellation of the franchise of the station on October 6, 1987. Suggested answer. The closing down of radio station XX during the fighting is permissible. With respect news media. Wartime censorship has been upheld on the ground that when a nation is at war, many things that might be said in time of peace are such a hindrance to its efforts that their utterance will not be endured so long as men fight, and that no court could regard them as protected by any constitutional right. The security of community life may be protected against incitements to acts of violence and the overthrow by force of orderly government. Near v. Minnesota, 283 U.S. 697. Quoting Justice Halm's opinion in Skent v. United States, 249 U.S. 47, New York. Times v. United States, 403 U.S. 713. With greater reason than may censorship in times of emergency be justified in the case of broadcast media, since their freedom is somewhat lesser in scope. The impact of the vibrant speech, as Justice Dieras said, is forceful and immediate. Unlike readers of the printed work, a radio audience has lesser opportunity to cogitate, analyze, and reject the utterance. V. Dans. 137 SCRA 647. In FCC v. Pacifica Foundation, 438 U.S. 726, it was held that of all forms of communication, it is broadcasting which has received the most limited First Amendment protection. Impairment Clause, Basic Human Rights. Number 2, Sheila, an actress, signed a 2-year contract with Solidaridad Films. The film company undertook to promote her career and to feature her as the leading lady in at least 4 movies. In turn, Sheila promised that, for the duration of the contract, she shall not get married or have a baby, otherwise, she shall be liable to refund to the film company a portion of its promotion expenses. A. Does this contract impair, or impinge upon, any constitutionally protected liberty of Sheila? Explain. B. If Solidaridad Films tries to enforce this contract judicially, will this constitutionally protected liberty prevail? Explain. Suggested answer: A. Yes, the contract impairs the right of Sheila to marry and to procreate. The case of Loving vs. Virginia, 388 U.S. 1 and Zablotsky vs. Red Hale 434 U.S. 374 recognized the right to marry is a basic civil right. Likewise, the case of Skinner vs. Oklahoma, 316 U.S. 535 recognized that the right to procreate is a basic civil right. These rights are part of the liberty protected by the Due Process Clause in Section 1 Article 1 of the Constitution. B. Yes, the constitutionally protected liberty of Sheila will prevail, because it involves basic human rights. The waiver of these basic human rights is void. What Solidaridad Films is seeking to recover are promotion expenses. These involve property rights. As held in Philippine Blooming Mills Employees Organization vs. Philippine Blooming Mills, Inc., 51 SCRA 189, civil rights are superior to property rights. Alternative answer: the waiver of the right to marry and the right to procreate is valid. Enforcement of the contract does not entail enforcement of the stipulation not to marry and not to have a baby. It is limited to a refund of a portion of the promotion expenses incurred by Solidaridad Films. Involuntary servitude. Number 16, Joy, an RTC stenographer, retired at the age of 65. She left unfinished the transcription of her notes in a criminal case which was on appeal. The Court of Appeals ordered Joy to transcribe her notes. She refused to comply with the order, reasoning that she was no longer in the government service. The CA declared Joy in contempt of court and she was incarcerated. Joy filed a petition for habeas corpus arguing that her incarceration is tantamount to illegal detention and to require her to work since compensation would be involuntary servitude. Decide. Suggested answer: Joy be incarcerated for contempt of court for refusing to transcribe her stenographic notes. As held in Adoracian v. Gatmaitan, 64 SCRA 132, her incarceration does not constitute illegal detention. It is lawful, because it is the consequence of her disobedience of the court order. Neither can she claim that to require her to work without compensation is tantamount to involuntary servitude. Since courts have the inherent power to issue such orders as are necessary for the administration of justice, the Court of Appeals may order her to transcribe her stenographic notes even if she is no longer in the government service. Liberty of abode. Limitations. No. 8. Juan Casanova contracted Hansen's disease with open lesions. A law requires that lepers be isolated upon petition of the city health officer. The wife of Juan Casanova wrote a letter to the city health officer to have her formerly philandering husband confined in some isolated leprosarium. Juan Casanova challenged the constitutionality of the law as violating his liberty of abode. Will the suit prosper? Suggested answer. No, the suit will not prosper. Section 6, Article 3 of the Constitution provides, the liberty of abode and of changing the same within the limits prescribed by law shall not be impaired except upon lawful order of the court. The liberty of abode is subject to the police power of the state. Requiring the segregation of lepers is a valid exercise of police power. In Lorenzo S., Director of Health, 50 Phil 595, 598, the Supreme Court held, judicial notice will be taken of the fact that leprosy is commonly believed to be an infectious disease tending to cause one afflicted with it to be shunned and excluded from society, and that compulsory segregation of lepers as a means of preventing the spread of the disease is supported by high scientific authority. Liberty of abode, temporary. Number 2. The military commander in charge of the operation against rebel groups directed the inhabitants of the island which would be the target of attack by government forces to evacuate the area and offered the residents temporary military hamlet. Can the military commander force the residents to transfer their places of abode without a court order? Explain. Suggested answer. No. The military commander cannot compel the residents to transfer their places of abode without a court order. Under Section 6, Article 3 of the Constitution, a lawful order of the court is required before the liberty of abode and of changing the same can be impaired. Alternative answer, yes, the military commander can compel the residents to transfer their places of abode without a court order. If there is no reasonable time to get a court order and the change of abode is merely temporary, because of the exigency, this exercise of police power may be justified. Non-imprisonment for non-payment of debt. Number 12, seconds. 13 of PD 115. Provides that when the entrustee in a trust receipt agreement fails to deliver the proceeds of the sale or to return the goods if not sold to the entrustee bank, the entrustee is liable for estafa under the RPC. Does this provision not violate the constitutional right against imprisonment for non-payment of a debt? Explain. Suggested answer. No. Section 13 of Presidential Decree No. 115 does not violate the constitutional right against imprisonment for non-payment of a debt. As held in Lee vs. Rodel, 175 SCRA 100, the criminal liability arises from the violation of the trust receipt, which is separate and distinct from the loan secured by it. Penalizing such an act is police power, abatement of nuisance. The city of San Rafael passed an ordinance authorizing the city mayor, assisted by the police, to remove all advertising signs displayed or exposed to public view in the main city street, for being offensive to sight or otherwise a nuisance. AM, whose advertising agency owns and rents out many of the billboards ordered removed by the city mayor, claims that the city should pay for the destroyed billboards at their current market value since the city has appropriated them for the public purpose of city beautification. The mayor refuses to pay, so AM is suing the city and the mayor for damages arising from the taking of his property without due process nor just compensation. Will AM prosper? Reason briefly. First alternative answer, the suit of AM will not prosper. The removal of the billboards is not an exercise of the power of eminent domain but of police power. Churchill. V. Rafferty, 32 Philosophy 581-9150. The abatement of a nuisance in the exercise of police power does not constitute taking of property and does not entitle the owner of the property involved to compensation. Association of Small Landowners in the Philippines, Inc. v. Secretary of Agrarian Reform, 175 SCRA 343. Second alternative answer. The removal of the billboards for the purpose of beautification permanently deprived AM of the right to use his property in amounts to its taking. Consequently, he should be paid just compensation. Police power, ban on tobacco AD. Number 1. Congress passes a law prohibiting television stations from airing any commercial advertisement which promotes tobacco or in any way glamorizes the consumption of tobacco products. This legislation was passed in response to findings by the Department of Health about the alarming rise in lung diseases in the country. The World Health Organization has also reported that U.S. tobacco companies have shifted marketing efforts to the Third World due to dwindling sales in the health-conscious American market. Cowboy Levi's, a jeans company, recently released an advertisement featuring model Richard Burgos wearing Levi's jackets and jeans and holding a pack of Marlboro cigarettes. The Asian Broadcasting Network, a privately owned television station, refuses to air the advertisement in compliance with the law. Decide the constitutionality of the law in question. Suggested answer. The law is constitutional. It is a valid exercise of police power, because smoking is harmful to health. In Posadas de Puerto Rico Associates vs. Tourism Company of Puerto Rico, 478 U.S. 328, it was ruled that a law prohibiting certain types of advertisements is valid if it was adopted in the interest of the health, safety, and welfare of the people. In Capital Broadcasting Company US. Mitchell 333 F. Sup 582, a law making it unlawful to advertise cigarettes on any medium of electronic communication was upheld. The United States Supreme Court summarily sustained this ruling in Capita. Broadcasting Company US, Acting Attorney General 405 U.S. 1000. The law in question was enacted on the basis of the legislative finding that there is a need to protect public health, because smoking causes lung diseases. Cowboy Levi's has not overthrown this finding. Police power, Zoning Ordinance vs. Non-impairment of contracts. Number 12. Pedro bought a parcel of land from Smart Corporation, a realty firm engaged in developing and selling lots to the public. One of the restrictions in the deed of sale which was annotated in the title is that the lot shall be used by the buyer exclusively for residential purposes. A main highway having been constructed across the subdivision, the area became commercial in nature. The municipality later passed a zoning ordinance declaring the area as a commercial bank building on his lot. Smart Corporation went to court to stop the construction as violative of the building restrictions imposed by it. The corporation contends that the zoning ordinance cannot nullify the contractual obligation assumed by the buyer. Decide the case. Suggested answer. The case must be dismissed. As held in Ortegas & Company, Limited Partnership vs. FEAT2 Bank and Trust Company, 94 SCRA 533, such a restriction in the contract cannot prevail over the zoning ordinance, because the enactment of the ordinance is a valid exercise of police power. It is hazardous to health and comfort to use the lot for residential purposes, since a highway crosses the subdivision and the area has become commercial. Police power, zoning ordinance vs non-impairment of contracts. No 18 in the deeds of sale to, and in the land titles of homeowners of a residential subdivision in Pasig City. There are restrictions annotated therein to the effect that only residential houses or structures may be built or constructed on the lots. However, the City Council of Pasig enacted an ordinance amending the existing zoning ordinance by changing the zone classification in that place from purely residential to commercial. A lot owner sold his lot to a banking firm, and the latter started constructing a commercial building on the lot to house a bank inside the subdivision. The subdivision owner and the homeowners association filed a case in court to stop the construction of the building for banking business purposes and to respect the restrictions embodied in the deed of sale by the subdivision developer to the lot owners, as well as the annotation in the titles. If you were the judge, how would you resolve the case? Suggested answer. If I were the judge, I would dismiss the case. As held in Ortegas and Company Limited Partnership vs. Fide Bank and Trust Company. 94 SCRA 633, the zoning ordinance is a valid exercise of police power and prevails over the contractual stipulation restricting the use of the lot to residential purposes. Privacy of communication. Note 12, A has a telephone line with an extension. One day, A was talking to B over the telephone. A conspired with his friend C, who was at the end of the extension line listening to A's telephone conversation with B in order to overhear and tape record the conversation, wherein B confidentially admitted that with evident premeditation he killed D for having cheated him in their business partnership. B was not aware that the telephone conversation was being tape recorded. In the criminal case against B for murder, is the tape-recorded conversation containing his admission admissible in evidence? Why? Suggested answer. The tape-recorded conversation is not admissible in evidence. As held in Salcedo Ordine vs Court of Appeals, 235 SCRA 111. Republic Act No. 4200 makes the tape recording of a telephone conversation done without the authorization of all the parties to the conversation inadmissible in evidence. In addition, the taping of the conversation violated the guarantee of privacy of communications enunciated in Section 3, Article 3 of the Constitution. Privacy of correspondence. No. 7. The police had suspicions that Juan Sampson, member of the subversive New Proletarian Army, was using the mail for propaganda purposes in gaining new adherents to its cause. The chief of police of Bantolan, Lana Odell Sur, ordered the postmaster of the town to intercept and open all mail addressed to and coming from Juan Sampson in the interest of the national security. Was the order of the chief of police valid? Suggested answer. No, the order of the chief of police is not valid, because there is no law which authorizes him to order the postmaster to open the letters addressed to and coming from Juan Sampson. An official in the executive department cannot interfere with the privacy of correspondence and communication in the absence of a law authorizing him to do so or a lawful order of the court. Section 3, Article 3 of the Constitution provides, the privacy of communication and correspondence shall be inviolable except upon lawful order of the court, or when public safety or order requires otherwise as prescribed by law. Privacy of correspondence, jail. Number 8, while serving sentence in Muntinlupa for the crime of theft, X stabbed dead one of his guards. X was charged with murder. During his trial, the prosecution introduced as evidence a letter written in prison by X to his wife tending to establish that the crime of murder was the result of premeditation. The letter was written voluntarily. In the course of inspection, it was opened and read by a warden pursuant to the rules of discipline of the Bureau of Prisons, and considering its contents, the letter was turned over to the prosecutor. The lawyer of X objected to the presentation of the letter and moved for its return on the ground that it violates the right of X against unlawful search and seizure. Decide. Suggested answer. The objection of the lawyer must be sustained. Section 3, Article 4 of the 1987 Constitution provides, "The privacy of communication and correspondence shall be inviolable except upon lawful order of the court, or when public safety or order requires otherwise as prescribed by law." There was no court order which authorized the warden to read the letter of X. Neither is there any law specifically authorizing the Bureau of Prisons to read the letter of X, under Section 3, Article 3 of the 1987 Constitution, to interfere with any correspondence when there is no court order. There must be a law authorizing it in the interest of public safety or order. The ruling of the United States Supreme Court in the case of Stroud vs. United States, 251 U.S. 15 is not applicable here, because Section 3, Article 3 of the 1987 Constitution has no counterpart in the American Constitution. Hence, in accordance with Section 3, Article 3 of the 1987 Constitution, the letter is inadmissible in evidence. Alternative answer. The objection of the lawyer must be overruled. In Hudson vs. Palmer, 468 U.S. 517, it was held that the constitutional prohibition against illegal searches and seizures does not extend to the confines of the prison. In Stroud vs. United States, 251 U.S. 15, the United States Supreme Court held that letters voluntarily written by a prisoner and examined by the warden which contained incriminatory statements were admissible in evidence. Their inspection by the prison authorities did not violate the constitutional prohibition against illegal searches and seizures. This is an established practice reasonably designed to promote discipline within the penitentiary. Right to assembly, permit application. Freedom Parks. The Samahan Ngmga Mahirap filed with the Office of the City Mayor of Manila an application for permit to hold a rally on Mendiola Street on September 5, 2006 from 10 o'clock a.m. to 3 p.m. to protest the political killings of journalists. However, the city mayor denied their application on the ground that a rally at the time and place applied for will block the traffic in the San Miguel and Quiapo districts. He suggested the Luisang Bonifacio, which has been designated a Freedom Park, as venue for rally. 1. Does the SM have a remedy to contest the denial of its application for a permit? Suggested answer. Yes, SM has a remedy. Under BP Big 880, in the event of denial of the application for a permit, the applicant may contest the decision in an appropriate court of law. The court must decide within 24 hours from the date of filing of the case. Said decision may be appealed to the appropriate court within 48 hours after receipt of the same. In all cases, any decision may be appealed to the Supreme Court, Bayan Muna v. Ermita, GR number 169838, April 25, 2006. 2. Does the availability of a Freedom Park justify the denial of SM's application for a permit? Suggested answer. No, the availability of a Freedom Park does not justify the denial of the permit. It does imply that no permits are required for activities in Freedom Parks. Under BP Big 880, the denial may be justified only if there is clear and convincing evidence that the public assembly will create a clear and present danger to public order, public safety, public convenience, public morals, or public health. Bayan Muna v. Ermita, GR No. 169,838, April 25, 2006. 3 is the requirement to apply for a permit to hold a rally a prior restraint on freedom of speech and assembly? Suggested answer. No, the requirement for a permit to hold a rally is not a prior restraint on freedom of speech and assembly. The Supreme Court has held that the permit requirement is valid, referring to it as regulation of the time, place, and manner of holding public assemblies, but not the content of the speech itself. Thus, there is no prior restraint, since the content of the speech is not relevant to the regulation. Bayan Muna v. Ermita, Gr. No. 169,838, April 25, 2006. 4. Assuming that despite the denial of SM's application for a permit, its members hold a rally, prompting the police to arrest them. Are the arrests without judicial warrants lawful? Suggested answer. The arrests are unlawful. What is prohibited and penalized under Sector 13 and 14 of BP? Big 880 is the assembly as defined in this act by any leader or organizer without having first secured that written permit, where a permit is required from the office concerned XXX, provided, however, that no person can be punished or held criminally liable for participating in or attending an otherwise peaceful assembly. Thus, only the leader or organizer of the rally without a permit may be arrested without a warrant, while the members may not be arrested, as they cannot be punished or held criminally liable for attending the rally. However, under Section 12 thereof, when the public assembly is held without a permit where a permit is required, the said public assembly may be peacefully dispersed. Right to assembly, permit requirements. Number 4, Olympia Academy, a private university, issued a student regulation for maintaining order in the school campus and to ensure that academic activities shall be conducted effectively. Henceforth, every student organization intending to hold any symposium, convocation, rally, or any assembly within school property and involving at least 20 people must file, for the prior approval of the Dean of Students, an application setting forth the time, place, expected size of the group, and the subject matter and purpose of the assembly. The League of Nationalist Students questions the validity of the new regulation. Resolve. Suggested answer. The regulation is valid. As held in Rarnento Us. Malabanan, 129 SCRA 359, if an assembly will be held by students in school premises, permit must be sought from the school authorities, who are devoid of the power to deny such request arbitrarily or unreasonably. In granting such permit, there may be conditions as to the time and place of the assembly to avoid disruption of classes or stoppage of work of the non-academic personnel. Right to assembly, public teachers. Note 12. Public school teachers staged for days mass actions at the Department of Education, Culture, and Sports to press for the immediate grant of their demand for additional pay. They DECS secretary issued to them a notice of the illegality of their unauthorized action, ordered them to immediately return to work, and warned them of imposable sanctions. They ignored this and continued with their mass action. The DECS secretary issued orders for their preventive suspension without pay and charged the teachers with gross misconduct and gross neglect of duty for unauthorized abandonment of teaching posts and absences without leave. A. Are employees in the public sector allowed to form unions? To strike? Why? B. The teachers claim that their right to peaceably assemble and petition the government for redress of grievances has been curtailed. Are they correct? Why? Suggested answer. A. Section 8, Article 3 of the Constitution allows employees in the public sector to form unions. However, they cannot go on strike. As explained in Social Security System Employees Association v. Court of Appeals. 175 SCRA 686, the terms and conditions of their employment are fixed by law. Employees in the public sector cannot strike to secure concessions from their employer. B. The teachers cannot claim that their right to peaceably assemble and petition for the redress of grievances has been curtailed. According to Bangladesh v. Court of Appeals. 276 SCRA 619. They can exercise this right without stoppage of classes. Right to assembly, public teachers. No. 10 public school teachers of Caloocan City left their classrooms to join a strike, which lasted for 1 month, to ask for teachers' benefits. The Department of Education, Culture, and Sports charged them administratively, for which reason they were required to answer and formally investigated by a committee composed of the Division Superintendent of Schools as chairman, the Division Supervisor as member and a teacher as another member. On the basis of the evidence adduced at the formal investigation which amply established their guilt, the director rendered a decision meting out to them the penalty of removal from office. The decision was affirmed by the DECS Secretary and the Civil Service Commission. On appeal, they reiterated the arguments they raised before the administrative bodies, namely, their strike was an exercise of their constitutional right to peaceful assembly and to petition the government for redress of grievances. Suggested answer. According to De La Cruz v. Court of Appeals, 305 SCRA 303, the argument of the teachers that they were merely exercising their constitutional right to peaceful assembly and to petition the government for redress of grievance cannot be sustained, because such rights must be exercised within reasonable limits. When such rights were exercised on regular school days instead of during the free time of the teachers committed acts prejudicial to the best interests of the service. Right to travel, order of arrest. Number 6, Mr. Esteban Cronati, a Filipino citizen, is arrested for the crime of smuggling. He posts bail for his release. Subsequently, he jumps bail and is about to leave the country when the Department of Foreign Affairs cancels his passport. He sues the DFA, claiming violation of his freedom to travel, citing the new provision in the Bill of Rights of the 1987 Constitution, to wit, neither shall right to travel be impaired except in the interest of national security, public safety, or public health, as may be provided by law. Decide the case. Suggested answer. The case should be dismissed. Any person under an order of arrest is under restraint and therefore he cannot claim the right to travel. If he is admitted to bail, his freedom of movement is confined within the country. Therefore, if he subsequently jumps bail, he cannot demand passport, which in effect will facilitate his escape from the country. He is in fact liable to be arrested anytime. Indeed, the right to travel under the Constitution supposes that the individual is under no restraint such as that would follow from the fact that one has a pending criminal case and has been placed under arrest. Rights of the accused, counsel of his choice. Mariano was arrested by the NBI as a suspect in the shopping mall bombings. Advised of his rights, Mariano asked for the assistance of his relative, attorney Santos. The NBI noticed that attorney Santos was inexperienced, incompetent, and inattentive. Deeming him unsuited to protect the rights of Mariano, the NBI dismissed attorney Santos. Appointed in his place was attorney Barroso, a bar top-notcher who was in the premises visiting a relative. Attorney Barroso ably assisted Mariano when the latter gave a statement. However, Mariano assailed the investigation, claiming that he was deprived of counsel of his choice. Was the NBI correct in dismissing attorney Santos and appointing attorney Barroso in his stead? Is Mariano's statement, made with the assistance of attorney Barroso, admissible in evidence? Alternative answer. The NBI was not correct in dismissing Attorney Santos and appointing Attorney Barroso in his stead. Article 3. Section 12 of the 1987 Constitution requires that a person under investigation for the commission of an offense shall have no less than competent and independent counsel, preferably of his own choice. This is meant to stress the primacy accorded to the voluntariness of the choice under the uniquely stressful conditions of a custodial investigation. Thus, the lawyer called to be present during such investigation should be, as far as reasonably possible, the choice of the individual undergoing questioning. The appointment of Attorney Barroso is questionable because he was visiting a rev working in the NBI and thus his independence is doubtful. Lawyers engaged by the police, whatever testimonials are given as proof of their probity and supposed independence, are generally suspect, as in many areas. The relationship between lawyers and law enforcement authorities can be symbiotic. Considering that Mariano was deprived of counsel of his own choice, the statement is inadmissible in evidence. Alternative answer. The NBI was correct in dismissing Attorney Santos as he was incompetent. The 1987 Constitution requires counsel to be competent and independent. Attorney Barroso, being a bar top-notcher, ably assisted Mariano, and there is no showing that his having a relative in the NBI affected his independence. Moreover, the accused has the final choice of counsel, as he may reject the one chosen for him and ask for another. A lawyer provided by the investigators is deemed engaged by the accused where he raises no objection against the lawyer during the course of the investigation, and the accused thereafter subscribes to the truth of his statement before the swearing officer. Thus, once the prosecution shows there was compliance with the constitutional requirement on pre-interrogation advisories, a confession is presumed to be voluntary and the declarant bears the burden of proving that his confession is involuntary and untrue. A confession is admissible until the accused successfully proves that it was given as a result of violence, intimidation, threat, or promise of reward or leniency, which are not present in this case. Accordingly, the statement is admissible. Rights of the accused: presumption of innocence vs. presumption of theft. Ounce lost 5 head of cattle which he reported to the police as stolen from his barn. He requested several neighbors, including RR, for help in looking for the missing animals. After an extensive search, the police found 2 head in RR's farm. RR could not explain to the police how they got hidden in a remote area of his farm. Insisting on his innocence, RR consulted a lawyer who told him he has a right to be presumed innocent under the Bill of Rights. But there is another presumption of theft arising from his unexplained possession of stolen cattle under the penal law. Are the two presumptions capable of reconciliation in this case? If so, how can they be reconciled? If not, which should prevail? Suggested answer. The two presumptions can be reconciled. The presumption of innocence stands until the contrary is proved. It may be overcome by a contrary presumption founded upon human experience. The presumption that RR is the one who stole the cattle of Ounce is logical, since he was found in possession of the stolen cattle. RR can prove his innocence by presenting evidence to rebut the presumption. The burden of evidence is shifted to RR, because how he came into possession of the cattle is peculiarly within his knowledge. Rights of the accused: right to bail. Number 9. Johan learned that the police were looking for him in connection with the rape of an 18-year-old girl, a neighbor. He went to the police station a week later and presented himself to the desk sergeant. Coincidentally, the rape victim was in the premises executing an extrajudicial statement. Johan, along with 6 other suspects, were placed in a police lineup and the girl pointed to him as the rapist. Johan was arrested and locked up in a cell. Johan was charged with rape in court, but prior to arraignment invoked his right to preliminary investigation. This was denied by the judge, and thus, trial proceeded. After the prosecution presented several witnesses, Johan through counsel, invoked the right to bail and filed a motion therefor, which was denied outright by the judge. Johan now files a petition for certiorari before the Court of Appeals arguing that he is entitled to bail as a matter of right, thus the judge should not have denied his motion to fix bail outright. Decide. Suggested answer. 3. In accordance with Art. 3 SEC 13 of the Constitution, Johan may be denied bail if the evidence of his guilt is strong considering that the crime with which he is charged is punishable by reclusion perpetua. It is thus not a matter of right for him to be released on bail in such case. The court must first make a determination of the strength of the evidence on the basis of evidence already presented by the prosecution, unless it desires to present some more, and give the accused the opportunity to present countervailing evidence. If having done this the court finds the evidence not to be strong, then it becomes the right of Johan to be admitted to bail. The error of the trial court lies in outrightly denying the motion for bail of Johan. Rights of the accused. Right to bail, capital offense. State whether or not the law is constitutional. Explain briefly. 2. A law denying persons charged with crimes punishable by reclusion perpetua or death the right to bail. Suggested answer. The law is invalid as it contravenes Section 13, Article 3 of the 1987 Constitution, which provides that all persons, except those charged with offences punishable by reclusion perpetua when evidence of guilt is strong, shall, before conviction, be bailable by sufficient sureties, or be released on recognizance as may be provided by law. The accused may not be deprived of his constitutional right to bail even if charged with a capital offense where the evidence of guilt is not strong. Rights of the accused. Right to bail, deportation case. Number 15. May an alien invoke the constitutional right to bail during the pendency of deportation proceedings? Suggested answer. No, an alien may not invoke the constitutional right to bail during the pendency of deportation proceedings. In Harvey vs. Santiago, 162 SCRA 840, it was held that the constitutional guarantee to bail may not be invoked in deportation proceedings, because they do not partake of the nature of a criminal action. Rights of the accused. Right to bail, matter of right or a matter of discretion. A. State with reason whether bail is a matter of right or a matter of discretion in the following cases. A. The imposable penalty for the crime charged is reclusion perpetua and the accused is a minor. Suggested answer. If the accused is a minor where the imposable penalty for the crime charged is reclusion perpetua, bail would be a matter of right. Under Article 68 of the Revised Penal Code, when the offender is a minor under 18 years of age, he is entitled to a penalty, depending on his age, lower by 1 or 2 degrees than that prescribed by law for the crime committed. The Constitution withholds the guarantee of bail from one who is accused of a capital offense where the evidence of guilt is strong. The obvious reason is that one who faces a probable death sentence has a particularly strong temptation to flee. This reason does not hold where the accused has been established without objection to be a minor who by law cannot be sentenced to death. Bravo v. Borgia, GR No. L 65228, February 18, 1985. B. The imposable penalty for the crime charged is life imprisonment and the accused is a minor. Alternative answer. If the accused is a minor and the imposable penalty for the crime charged is life imprisonment, bail would not be a matter of right. In the instant case, assuming that evidence of guilt strong, bail shall be denied as the privileged mitigating circumstance of minority is not available for violation of special laws penalized by life imprisonment. Alternative answer. Although the Constitution mentions only reclusion perpetua, Rule 114 of the Rules of Court adds life imprisonment, and therefore, applying the pro reo doctrine, bail would still be a matter of right, since it is favorable to the accused. C. The accused has been convicted of homicide on a charge of murder and sentenced to suffer an indeterminate penalty of from 8 years and 1 day of prison mayor, as minimum, to 12 years and 4 months of reclusion temporal, as maximum. Suggested answer. If the accused has been convicted of homicide on a charge of murder and sentenced to suffer imprisonment of from 8 to 12 years, bail is a matter of discretion. Under Rule 114, Sector 5, PAR. One of the rules of court, if the decision of the trial court convicting the accused changed the nature of the offense from non-bailable to bailable, the application for bail may be filed and acted upon by the appellate court. Admission to bail is discretionary. Rights of the accused, right to speedy trial. No. 15. Charged by Francisco with libel, Pablo was arraigned on January 3, 2000, pre-trial was dispensed with and continuous trial was set for March 7, 8 and 9, 2000. On the first setting, the prosecution moved for its postponement and cancellation of the other settings because its principal and probably only witness, the private complainant Francisco, suddenly had to go abroad to fulfill a professional commitment. The judge instead dismissed the case for failure to prosecute. A. Would the grant of the motion for postponement have violated the accused right to speedy trial? Suggested answer. The grant of the motion for postponement would not have violated the right of the accused to speedy trial. As held in People v. Levist, 255 SCRA 238. Since the motion for postponement was the first one requested, the need for the offended party to attend to a professional commitment is a valid reason. No substantial right of the accused would be prejudiced. And the prosecution should be afforded a fair opportunity to prosecute its case. The motion should be granted. Alternative answer. Since continuous trial of cases is required and since the date of the initial hearing was set upon agreement of all parties, including the rights of the accused, self-incrimination. Number 3, Dr. Juan Stowe. Tomas is a practicing dentist in Marikina, Metro Manila. He was charged with immorality before the Board of Dentistry by a lady patient, who claims that Dr. Stowe Tomas took liberties with her person and kissed her while she was under the treatment at the latter's clinic. At the initial hearing of the administrative complaint, the complainant's counsel called the respondent as his first witness. The respondent, through counsel, objected vigorously, claiming his constitutional right to be exempt from being a witness against himself. The board noted the objection, but ruled that in the next scheduled hearing, a month and a half later, the respondent would be called to testify as a witness, as the right he claims is not available in administrative investigations, but only in criminal prosecutions. Dr. Stowe Tomas has decided not to testify. As his lawyer, what would you do? Why? Suggested answer. I will file a petition for prohibition with prayer for preliminary injunction with the regional trial court. The privilege against self-incrimination is available not only in judicial proceedings but also in administrative investigations. In Pascual v. Board of Medical Examiners, 28 SCRA 344. It was held that the revocation of a license as a medical practitioner can be an even greater deprivation than mere forfeiture of property. In some aspects it is similar to criminal proceedings and, therefore, the respondent cannot be made to testify as a witness for the complainant. Rights of the accused, self-incrimination. Number 4. The privilege of self-incrimination must be timely invoked, otherwise it is deemed waived. 1. In a civil case, the plaintiff called the defendant a hostile witness and announced that the defendant would be asked incriminating questions in the direct examination. When should the defendant invoke the privilege against self-incrimination? 2. In a criminal case, the prosecution called the accused to the witness stand as the first witness in view of certain facts. 3. In an administrative case for malpractice and the cancellation of license to practice medicine filed against C, the complainant called C to the witness stand. When should C invoke the privilege against self-incrimination? Explain your answers to the 3 questions. Suggested answer. As held in Bagadian v. de Guzman, 94 SCRA 906, the defendant should take the witness stand and object when a question calling for an incriminating question is propounded. Unlike in proceedings which are criminal in character in which the accused can refuse to testify, the defendant must wait until a question calling for an incriminatory answer is actually asked. Suarez v. Tonko, 2 SCRA 71. As held in Chavez v. Court of Appeals, 24 SCRA 663, in a criminal case the accused may altogether refuse to take the witness and refuse to answer any question, because the purpose of calling him as a witness for the prosecution has no other purpose but to incriminate him. As in a criminal case, C can refuse to take the witness stand and refuse to answer any question. In Pascual v. Board of Medical Examiners, 28 SCRA 344, it was held that an administrative case for malpractice and cancellation of the license to practice medicine is penal in character. Because an unfavorable decision would result in the revocation of the license of the respondent to practice medicine. Consequently, he can refuse to take the witness stand. Rights of the accused, self-incrimination. No. 3. Congress is considering a law against drunken driving. Under the legislation, police authorities may ask any driver to take a breathalyzer test, wherein the driver exhales several times into a device which can determine whether he has been driving under the influence of alcohol. The results of the test can be used in any legal proceeding against him. Furthermore, declaring that the issuance of a driver's license gives rise only to a privilege to drive motor vehicles on public roads. The law provides that a driver who refuses to take the test shall be automatically subject to a 90-day suspension of his driver's license. Cite 2 possible constitutional objections to this law. Resolve the objections and explain whether any such infirmities can be cured. Suggested answer. Possible objections to the law are that requiring a driver to take the breathalyzer test will violate his right against self-incrimination, that providing for the suspension of his driver's license without any hearing violates due process, and that the proposed law will violate the right against unreasonable searches and seizures, because it allows police authorities to require a driver to take the breathalyzer test even if there is no probable cause. Requiring a driver to take a breathalyzer test does not violate his right against self-incrimination, because he is not being compelled to give testimonial evidence. He is merely being asked to submit to a physical test. This is not covered by the constitutional guarantee against self-incrimination. Thus, in South Dakota vs. Neville, 459 U.S. 553, it was held for this reason that requiring a driver to take a blood alcohol test is valid. As held in McKee vs. Afantria 443 U.S. 1, because of compelling government interest in safety along the streets, the license of a driver who refuses to take the breathalyzer test may be suspended immediately pending a post-suspension hearing. But there must be a provision for a post-suspension hearing. Thus, to save the proposed law from unconstitutionally on the ground of denial of due process, it should provide for an immediate hearing upon suspension of the driver's license. The proposed law violates the right against unreasonable searches and seizures. It will authorize police authorities to stop any driver and ask him to take the breathalyzer test even in the absence of a probable cause. Rights of the accused, self-incrimination. No. 11. B. A man was shot and killed and his killer fled. Moments after the shooting, an eyewitness described to the police that the slayer wore white pants, a shirt with floral design, had boots, and was about 70 kilos and 1.65 meters. Borja, who fit the description given, was seen nearby. He was taken into custody and brought to the police precinct where his pants, shirt, and boots were forcibly taken, and he was weighed, measured, photographed, fingerprinted and subjected to paraffin testing. At his trial, Borja objected to the admission in evidence of the apparel, his height and weight, his photographs, fingerprints comparison, and the results of the paraffin test, asserting that these were taken in violation of his right against self-incrimination. Rule on the objection. Suggested answer. B. The objection of Borja is not tenable. As held in People v. Painter, 261 SCRA 615, the rights guaranteed by Section 12, Article N of the Constitution applies only against testimonial evidence. An accused may be compelled to be photographed or measured, his garments may be removed, and his body may be examined. Rights of the accused, self-incrimination. Select the best answer and explain. 1. An accused right against self-incrimination is violated in the following cases: v. When he is ordered by the trial court to undergo a paraffin test to prove he is guilty of murder. P. When he is compelled to produce his bank books to be used as evidence against his father charged with plunder. P. When he is ordered to produce a sample of his handwriting to be used as evidence that he is the author of a letter wherein he agreed to kill the victim. A. When the president of a corporation is subpoenaed to produce certain documents as proofs he is guilty of illegal recruitment. Suggested answer. The best answer is C. When he is ordered to produce a sample of his handwriting to be used as evidence that he is the author of a letter wherein he agreed to kill the victim. Under Article High, Section 17 of the 1987 Constitution, no person shall be compelled to be a witness against himself. Since the provision prohibits compulsory testimonial incrimination, it does not matter whether the testimony is taken by oral or written means, as either way it involves the use of intellectual faculties. The purpose of the privilege is to avoid and prohibit thereby the repetition and recurrence of compelling a person, in a criminal or any other case, to furnish the missing evidence necessary for his conviction. Bermudez v. Castillo, per Rec. No. 714a, July 26, 1937, Beltran v. Sampson, Gr. Number 32025, September 23, 1929. Searches and seizure, private individuals. Emilio had long suspected that Alvin had been passing trade secrets to his competitor, Randy, but he had no proof. One day, Emilio broke open the desk of Alvin and discovered a letter wherein Randy thanked Alvin for having passed on to him vital trade secrets of Emilio. Enclosed in the letter was a check for P50,000 drawn against the account of Randy and payable to Alvin. Emilio then dismissed Alvin from his employment. Emilio's proof of Alvin's perfidy are the said letter and check, which are objected to as inadmissible for having been obtained through an illegal search. Alvin filed a suit assailing his dismissal. Rule on the admissibility of the letter and check. Alternative answer. As held in People v. Marty, the Constitution, in laying down the principles of the government and fundamental liberties of the people, does not govern relationships between individuals. Thus, if the search is made at the behest or initiative of the proprietor of a private establishment for its own and private purposes and without the intervention of police authorities, The right against unreasonable search and seizure cannot be invoked for only the act of private individuals, not the law enforcers, is involved. In sum, the protection against unreasonable searches and seizures cannot be extended to acts committed by private individuals so as to bring it within the ambit of alleged unlawful intrusion by the government. Accordingly, the letter and check are admissible in evidence. Waterous Drug Corp v. NLRC, GR number 113271, October 16, 1997. Alternative answer. The letter is inadmissible in evidence. The constitutional injunction declaring the privacy of communication and correspondence to be inviolable is no less applicable simply because it is the employer who is the party against whom the constitutional provision is to be enforced. The only exception to the prohibition in the Constitution is if there is a lawful order from the court or when public safety or order requires otherwise, as prescribed by law. Any violation of this provision renders the evidence obtained inadmissible for any purpose in any proceeding. Searches and seizures, aliens. No. 4, A is an alien. State whether, in the Philippines, he is entitled to the right against illegal searches and seizures and against illegal arrests. Suggested answer. Aliens are entitled to the right against illegal searches and seizures and illegal arrests. As applied in People v. Chua Hosan, 307 SCRA 432, these rights are available to all persons, including aliens. Searches and seizures, breathalyzer test. No. 3. Congress is considering a law against drunken driving. Under the legislation, police authorities may ask any driver to take a breathalyzer test, wherein the driver exhales several times into a device which can determine whether he has been driving under the influence of alcohol. The results of the test can be used in any legal proceeding against him. Furthermore, declaring that the issuance of a driver's license gives rise only to a privilege to drive motor vehicles on public roads. The law provides that a driver who refuses to take the test shall be automatically subject to a 90-day suspension of his driver's license. Cite 2 possible constitutional objections to this law. Resolve the objections and explain whether any such infirmities can be cured. Suggested answer. Possible objections to the law are that requiring a driver to take the breathalyzer test will violate his right against self-incrimination. That providing for the suspension of his driver's license without any hearing violates due process, and that the proposed law will violate the right against unreasonable searches and seizures. Because it allows police authorities to require a driver to take the breathalyzer test even if there is no probable cause. Requiring a driver to take a breathalyzer test does not violate his right against self-incrimination, because he is not being compelled to give testimonial evidence. He is merely being asked to submit to a physical test. This is not covered by the constitutional guarantee against self-incrimination. Thus, in South Dakota vs. Neville, 459 U.S. 553, it was held for this reason that requiring a driver to take a blood alcohol test is valid. As held in McKee vs. Afontraya 443 U.S. 1, because of compelling government interest in safety along the streets, the license of a driver who refuses to take the breathalyzer test may be suspended immediately pending a post-suspension hearing. But there must be a provision for a post-suspension hearing. Thus, to save the proposed law from unconstitutionally on the ground of denial of due process, it should provide for an immediate hearing upon suspension of the driver's license. The proposed law violates the right against unreasonable searches and seizures. It will authorize police authorities to stop any driver and ask him to take the breathalyzer test even in the absence of a probable cause. Searches and seizures, immediate control. No. 3, a constabulary officer, was arrested pursuant to a lawful court order in Baguio City for murder. He was brought to Manila where a warrantless search was conducted in his official quarters at Camp Crame, the search team found and seized the murder weapon in a drawer of X. Can X claim that the search and seizure were illegal and move for exclusion from evidence of the weapon seized? Explain. Suggested answer. Yes, X can do so. The warrantless search cannot be justified as an incident of a valid arrest, because considerable time had elapsed after his arrest in Baguio before the search of his quarters in Camp Crame, Quezon City was made. And because the distance between the place of arrest and the place of search negates any claim that the place searched is within his immediate control so as to justify the apprehension that he might destroy or conceal evidence of crime before a warrant can be obtained. In Nolasco v. Cruz Pano, 147 SCRA 509, the Supreme Court reconsidered its previous decision holding that a warrantless search, made after 30 minutes from the time of arrest, and, in a place several blocks away from the place of arrest, was valid. It held that a warrantless search is limited to the search of the person of the arrestee at the time and incident to his arrest and for dangerous weapons or anything which may be used as proof of the offense. A contrary rule would justify the police in procuring a warrant of arrest and, by virtue thereof, not only arrest the person but also search his dwelling. A warrant requires that all facts as to the condition of the property and its surroundings and its improvements and capabilities must be considered, and this can only be done in a judicial proceeding. Searches and seizures, incidental to valid search. Number 9. Some police operatives, acting under a lawfully issued warrant for the purpose of searching for firearms in the house of X located at number 10 Shaw Boulevard, Pasay, Metro Manila, found, instead firearms, 10 kilograms of cocaine. May the said police operatives lawfully seize the cocaine? Explain your answer. May X successfully challenge the legality of the search on the ground that the peace officers did not inform him about his right to remain silent and his right to counsel? Explain your answer. Suppose the peace officers were able to find unlicensed firearms in the house in an adjacent lot, that is, No. 12 Shaw Boulevard, which is also owned by X. May they lawfully seize the said unlicensed firearms? Explain your answer. Suggested answer. Yes, the police operatives may lawfully seize the cocaine, because it is an item whose possession is prohibited by law. It was in plain view and it was only inadvertently discovered in the course of a lawful search. The possession of cocaine is prohibited by Section 8 of the Dangerous Drugs Act. As held in Magancia v. Palacio, 80 Phil. 770, an article whose possession is prohibited by law may be seized without the need of any search warrant if it was discovered during a lawful search. The additional requirement laid down in Roan v. Gonzalez, 145 SCRA 687 that the discovery of the article must have been made inadvertently was also satisfied in this case. No, X cannot successfully challenge the legality of the search simply because the peace officers did not inform him about his right to remain silent and his right to counsel. Section 12, Article 3 of the 1987 Constitution provides, any person under investigation for the commission of an offense shall have the right to be informed of his right to remain silent and to have competent and independent counsel, preferably of his own choice. As held in People v. DY, 158 SCRA 111. For this provision to apply, a suspect must be under investigation. There was no investigation involved in this case. The unlicensed firearms stored at 12 Shaw Boulevard may lawfully be seized since their possession is illegal. As held in Magancia a Palacio, 80 Philosophy 770, when an individual possesses contraband, he is committing a crime and he can be arrested without a warrant and the contraband can be seized. Number 4, Larry was an overnight guest in a motel. After he checked out the following day, the chambermaid found an attaché case which she surmised was left behind by Larry. She turned it over to the manager who, to determine the name and address of the owner, opened the attaché case and saw packages which had a packages, the contents of which upon laboratory examination, turned out to be marijuana flowering tops. Larry was alternative answer. In accordance with the rulings in Ui Keaton v. Villarreal, 42 Philosophy 886 and People v. S.Y. Juco, 64 Phil. 667, the unlicensed firearms found in the house at 12 Shaw Boulevard may not be lawfully seized, since they were not included in the description of the articles to be seized by virtue of the search warrant. The search warrant described the articles to be seized as firearms in the house of X located at 10 Shaw Boulevard. Searches and seizures, place of search. No. 11, armed with a search and seizure warrant, a team of policemen led by Inspector Trias entered a compound and searched the house described therein as number 17 Speaker Perez STA Mesa Heights, Quezon City, owned by Mr. Hernani Pallets, for a reported cache of firearms and ammunition. However, upon thorough search of the house, the police found nothing. Then, acting on a hunch, the policemen proceeded to a smaller house inside the same compound with address at No. 17A Speaker Perez Street, entered it, and conducted a search therein over the objection of Mr. Pallets, who happened to be the same owner of the first house. There, the police found the unlicensed firearms and ammunition they were looking for. As a result, Mr. Hernani Pallets was criminally charged in court with illegal possession of firearms and ammunition as penalized under P. D 1866, as amended by RA 8294. At the trial, he vehemently objected to the presentation of the evidence against him for being inadmissible. Is Mr. Hernani Pallets' contention valid or not? Why? Suggested answer. The contention of Hernani Pallets is valid. As held in People vs. Court of Appeals, 291 SCRA 400. If the place searched is different from that stated in the search warrant, the evidence seized is inadmissible. The policeman cannot modify the place to be searched as set out in the search warrant. Searches and seizures, search made by a private citizen. Peculiar smell and upon squeezing felt like dried leaves. His curiosity aroused, the manager made an opening on one of the packages and took several grams of the contents thereof. He took the packages to the NBI, and in the presence of agents, opened the plastic bag and its contents are inadmissible in evidence being the product of an illegal search and seizure, and subsequently found, brought to the NBI office where he admitted ownership of the case and the packages. He was made to sign a receipt for the packages. Larry was charged in court for possession of prohibited drugs. He was convicted. On appeal, he now poses the following issues. 1. The packages are inadmissible in evidence being the product of an illegal search and seizure. 2. Neither is the receipt he signed admissible, his rights under custodial investigation not have been observed. Decide. Suggested answer, on the assumption that the issues were timely raised, the answers are as follows. 1. The packages are admissible in evidence. The one who opened the packages was the manager of the motel without any interference of the agents of the National Bureau of Investigation. As held in People vs. Marty, 193 SCRA 57, the constitutional right against unreasonable searches and seizures refers to unwarranted intrusion by the government and does not operate as a restraint upon private individuals. 2. the receipt is not admissible in evidence. Searches and seizures, search made by a private citizen. No. 8. One day a passenger bus conductor found a man's handbag left in the bus. When the conductor opened the bag, he found inside a Jaclyn card with the owner's name, an address, a few hundred peso bills, and a small plastic bag containing a white powdery substance. He brought the powdery substance to the National Bureau of Investigation for laboratory examination, and it was determined to be methamphetamine hydrochloride or shabu, a prohibited drug. Jaclyn was subsequently traced and found and brought to the NBI office, where he admitted ownership of the handbag and its contents. In the course of the interrogation by NBI agents, and without the presence and assistance of counsel, Jaclyn was made to sign a receipt for the plastic bag and its shabu contents. Jaclyn was charged with illegal possession of prohibited drugs and was convicted. On appeal, he contends that the receipt he signed is also inadmissible, as his rights under custodial investigation were not observed. Decide the case with reasons. Suggested answer. A. The plastic bag and its contents are admissible in evidence, since it was not the National Bureau of Investigation but the bus conductor who opened the bag and brought it to the National Bureau of Investigation. As held in People v. Marty, 193 SCRA 57, the constitutional right against unreasonable search and seizure is a restraint upon the government. It does not apply so as to require exclusion of evidence which came into the possession of the government through a search made by a private citizen. B. It is admissible. Searches and seizures, valid warrantless search. A. Crack officers of the anti-narcotics unit were assigned on surveillance of the environs of a cemetery where the sale and use of dangerous drugs are rampant. A man with reddish and glassy eyes was walking unsteadily, moving towards them, but veered away when he sensed the presence of policemen. They approached him, introduced themselves as police officers, and asked him what he had clenched in his hand. As he kept mum, the policeman pried his hand open and found a sachet of shabu, a dangerous drug. Accordingly charged in court, the accused objected to the admission in evidence of the dangerous drug because it was the result of an illegal search and seizure. Rule on the objection. B. What are the instances when warrantless searches may be effected? Suggested answer. A. The objection is not tenable. In accordance with Manalili v. Court of Appeals, 280 SCRA 400. Since the accused had red eyes and was walking unsteadily and the place is a known hangout of drug addicts, the police officers had sufficient reason to stop the accused and to frisk him. Since shabu was actually found during the investigation, it could be seized without the need for a search warrant. B. A warrantless search may be effected in the following cases: A. Searches incidental to a lawful arrest. B. Searches of moving vehicles. C. Searches of prohibited articles in plain view. D. Enforcement of customs law. E. Consented searches. F. Stop and frisk. People v. Monaco, 285. SCRA 703. G. Routine searches at borders and ports of entry, United States v. Ramsey, 431 U.S. 606. NH. Searches of businesses in the exercise of visit-orial powers to enforce police regulations. Searches and seizures, visual search. Number 5. During the recent elections, checkpoints were set up to enforce the election period ban on firearms. During one such routine search one night, while looking through an open window with a flashlight, the police saw firearms at the back seat of a car partially covered by papers and clothes. Antonio, owner and driver of the car in question, was charged for violation of the firearms ban. Are the firearms admissible in evidence against him? Explain. If, upon further inspection by the police, prohibited drugs were found inside the various compartments of Antonio's car, can the drugs be used in evidence against Antonio if he is prosecuted for possession of prohibited drugs? Explain. Suggested answer. A. Yes, the firearms are admissible in evidence, because they were validly seized. In Valmonte vs. Davila, 178 SCRA 211 and 185 SCRA 665, the Supreme Court held that checkpoints may be set up to maintain peace and order for the benefit of the public, and checkpoints are a security measure against unauthorized firearms. Since the search which resulted in the discovery of the firearms was limited to a visual search of the car, it was reasonable. Because of the ban on firearms, the possession of the firearms was prohibited. Since they were found in plain view in the course of a lawful search, in accordance with the decision in Magancia vs. Palacio, 80 Phil. 770, they are admissible in evidence. B. No, the drugs cannot be used in evidence against Antonio if he is prosecuted for possession of prohibited drugs. The drugs were found after a more extensive search of the various compartments of the car. As held in Valmonte vs. Davila, 185 SCRA 665, for such a search to be valid, there must be a probable cause. In this case, there was no probable cause, as there was nothing to indicate that Antonio had prohibited drugs inside the compartments of his car. Searches and seizures, waiver of consent. Number 7. Pursuing reports that great quantities of prohibited drugs are being smuggled at nighttime through the shores of Cavite, the Southern Luzon Command set up checkpoints at the end of the Cavite coastal road to search passing motor vehicles. A 19-year-old boy, who finished 5th grade, while driving, was stopped by the authorities at the checkpoint. Without any objection from him, his car was inspected, and the search yielded marijuana leaves hidden in the trunk compartment of the car. The prohibited drug was promptly seized, and the boy was brought to the police station for questioning. Was the search without warrant legal? Suggested answer. No, the search was not valid, because there was no probable cause for conducting the search. As held in Almeida Sanchez vs. United States, 413 U.S. 266, while a moving vehicle can be searched without a warrant, there must still be probable cause. In the case in question, there was nothing to indicate that marijuana leaves were hidden in the trunk of the car. The mere fact that the boy did not object to the inspection of the car does not constitute consent to the search. As ruled in People vs. Burgos, 144 SCRA 1, the failure to object to a warrantless search does not constitute consent, especially in the light of the fact. Alternative answer. Yes. The requirement of probable cause differs from case to case. In this one, since the police agents are confronted with large-scale smuggling of prohibited drugs, existence of which is of public knowledge, they can set up checkpoints at strategic places. In the same way that if in a neighborhood a child is kidnapped, it is lawful to search cars and vehicles leaving the neighborhood or village. This situation is also similar to warrantless searches of moving vehicles in customs area. Which searches have been upheld? Papa vs. Mago, 22 SCRA 857. The rule is based on practical necessity. Searches and seizures, warrantless arrests. Number 9. Johan learned that the police were looking for him in connection with the rape of an 18-year-old girl, a neighbor. He went to the police station a week later and presented himself to the desk sergeant. Coincidentally, The rape victim was in the premises executing an extrajudicial statement. Jo-han, along with 6 other suspects, were placed in a police lineup and the girl pointed to him as the rapist. Jo-han was arrested and locked up in a cell. Jo-han was charged with rape in court but prior to arraignment invoked his right to preliminary investigation. This was denied by the judge, and thus, trial proceeded. After the prosecution presented several witnesses, Jo-han through counsel, invoked the right to bail and filed a motion therefor, which was denied outright by the judge. Jo-han now files a petition for certiorari before the Court of Appeals arguing that his arrest was not in accordance with law. Decide. Suggested answer. Yes, the warrantless arrest of Jo-han was not in accordance with law. As held in Go v. Court of Appeals, 206 SCRA 138, his case does not fall under the instances in Rule 113, Section 5 of the 1985 Rules of Criminal Procedure authorizing warrantless arrests. It cannot be considered a valid warrantless arrest because Jo-han did not commit a crime in the presence of the police officers, since they were not present when Jo-han had allegedly raped his neighbor. Neither can it be considered an arrest under Rule 113 seconds 5, which allows an arrest without a warrant to be made when a crime has in fact just been committed and the person making the arrest has personal knowledge offsets indicating that the person to be arrested committed it. Since Jo-han was arrested a week after the alleged rape, it cannot be deemed to be a crime which has just been committed. Nor did the police officers who arrested him have personal knowledge of facts indicating that Jo-han raped his neighbor. Searches and seizures, warrants of arrest. Number 8, on the basis of a verified report and confidential information that various electronic equipment, which were illegally imported into the Philippines, were found in the bodega of the Takasan Corporation located at 1002 Binakayan St. Cebu City, the Collector of Customs of Cebu issued, in the morning of January 2, 1988, a warrant of seizure and detention against the corporation for the seizure of the electronic equipment. The warrant particularly describes the electronic equipment and specifies the provisions of the Tariff and Customs Code which were violated by the importation. The warrant was served and implemented in the afternoon of January 2, 1988 by customs policemen who then seized the described equipment. The inventory of the seized articles was signed by the Secretary of the Takasan Corporation. The following day, a hearing officer in the Office of the Collector of Customs conducted a hearing on the confiscation of the equipment. 2 days thereafter, the corporation filed with the Supreme Court a petition for certiorari, prohibition, and mandamus to set aside the warrant, enjoin the collector and his agents from further proceeding with the forfeiture hearing and to secure the return of the confiscated equipment, alleging therein that the warrant issued is null and void for the reason that, pursuant to Section 2 of Article 3 of the 1987 Constitution, only a judge may issue a search warrant. In his comment to the petition, the Collector of Customs, through the Office of the Solicitor General, contends that he is authorized under the Tariff and Custom Code to order the seizure of the equipment whose duties and taxes were not paid and that the corporation did not exhaust administrative remedies. Should the petition be granted? Decide. Suggested answer. The petition should not be granted. Under SECS 2205 and 2208 of the Tariff and Customs Code, customs officials are authorized to enter any warehouse, not used as dwelling, for the purpose of seizing any article which is subject to forfeiture. For this purpose they need no warrant issued by a court. As stated in Vijaya v. Esperdiago, 73 SCRA 553. For centuries the seizure of goods by customs officials to enforce the customs laws without need of a search warrant has been recognized. Article 4 Citizenship Action 4. Cancellation, prescription and effect of death. Number 7, Enzo, a Chinese national, was granted Philippine citizenship in a decision rendered by the Court of First Instance of Pampanga on January 10, 1956. He took his oath of office on June 5, 1959. In 1970, the Solicitor General filed a petition to cancel his citizenship on the ground that in July 1969 the Court of Tax Appeals found that Enzo had cheated the government of income taxes for the years 1956 to 1959. Said decision of the tax court was affirmed by the Supreme Court in 1969. Between 1960 and 1970, Enzo had acquired substantial real property in the Philippines. Has the action for cancellation of Enzo's citizenship prescribed? Can Enzo ask for the denial of the petition on the ground that he had availed of the tax amnesty for his tax liabilities? What is the effect on the petition for cancellation of Enzo's citizenship if Enzo died during the pendency of the hearing on said petition? Suggested answer. 1. No, the action has not prescribed. As held in Republic vs. Li Yao, 214 SCRA 748, a certificate of naturalization may be cancelled at any time if it was fraudulently obtained by misleading the court regarding the moral character of the petitioner. 2. No, Enzo cannot ask for the denial of the petition for the cancellation of his certificate of naturalization on the ground that he had availed of the tax amnesty, in accordance with the ruling in Republic vs. Li Yao, 224 SCRA 748, the tax amnesty merely removed all the civil, criminal, and administrative liabilities of Enzo. It did not obliterate his lack of good moral character and irreproachable conduct. 3. On the assumption that he left a family, the death of Enzo does not render the petition for the cancellation of his certificate of naturalization moot. As held in Republic vs. Li Yao, 224 SCRA 748, the outcome of the case will affect his wife and children. Citizenship, elected official. Number 7, Ferdy immigrated to the United States in the 1980s. Thereafter, he visited his hometown, Makahoy, every other year during town fiestas. In January 1993, Ferdy came home and filed his certificate of candidacy for mayor of Makahoy. He won in the elections. Joe, the defeated candidate, learned that Ferdy is a green card holder which on its face identifies Ferdy as a resident alien. And on the back thereof is clearly printed, person identified by this card is entitled to reside permanently and work in the United States. Joe filed a case to disqualify Ferdy from assuming the mayorship of Makahoy. Questions. Whether or not a green card is proof that the holder is a permanent resident of the United States. Whether or not Ferdy's act of filing his certificate of candidacy constitutes waiver of his status as a permanent resident of the United States. Suggested answer. 1. According to the ruling in Coast vs. Court of Appeals, 191 SCRA 229, a green card is proof that the holder is a permanent resident of the United States. For it identifies the holder as a resident of the United States and states that the holder is entitled to reside permanently and work in the United States. 2. The filing of a certificate of candidacy does not constitute a waiver of the status of the holder of a green card as a permanent resident of the United States. As held in Coast vs. Court of Appeals, 191 SCRA 229, the waiver should be manifested by an act independent of and prior to the filing of his certificate of candidacy. Dual allegiance vs. dual citizenship. No. 8. A was born in 1951 in the United States of a Chinese father and a Filipina mother. Under Chinese laws, A's mother automatically became a Chinese national by her marriage. In 1973, upon reaching the age of majority, A elected to acquire Philippine citizenship. However, A continued to reside in California and to carry an American passport. He also paid allegiance to the Taipei government. In the 1987 Philippine national elections, he was elected senator. His opponent moved to disqualify him on the grounds A. that he was not a natural-born citizen, and B. that he had dual allegiance not only to the United States but also to the Republic of China. Decide. Suggested answer. The electoral contest must be dismissed. A is a natural-born citizen. Art. 4. Sector 2 of the 1987 Constitution provides that those who elect Philippine citizenship in accordance with paragraph 2 1 hereof shall be deemed natural-born citizens. The purpose of this provision is to equalize the status of those who elected Philippine citizenship before and those who did so after January 17, 1973, when the previous constitution took effect. The dual allegiance declared inimical to national interest in Art. 4. Sector 5 refers to the dual allegiance of some such as naturalized Filipino citizens who maintain allegiance to nationalist China as shown in some cases by their membership in the Legislative Yuan after their naturalization as citizens of the Philippines. The prohibition does not apply in situations brought about by dual citizenship, such as the one involved in the problem. Indeed, a Filipino woman can have dual allegiance resulting from her marriage to a foreigner under Sector 4, so long as she does not do or omit to do an act amounting to renunciation under Commonwealth Act. Number 63, Sector 1. Under this law, express renunciation is different from an act of allegiance to a foreign power as a ground for loss of Philippine citizenship. Moreover, what constitutes dual allegiance, inimical to national interest is and what the sanctions for such dual allegiance will be, will still have to be defined by law pending adoption of such legislation. Action based on dual allegiance will be premature. Dual allegiance vs. dual citizenship. Number 13, Robert Brown was born in Hawaii on May 15, 1962, of an American father and a Filipina mother. On May 16, 1983, while holding an American passport, he registered as a Filipino with the Philippine Consulate at Honolulu, Hawaii. In September 1983 he returned to the Philippines, and took up residence at Boac, Marinduque, hometown of his mother. He registered as a voter, voted, and even participated as a leader of one of the candidates in that district in the 1984 Batasan elections. In the elections of 1987, he ran for congressman, and won. His sole opponent is now questioning his qualifications and is trying to oust him on two basic claims. He is not a natural-born Filipino citizen, but is in fact an American, born in Hawaii, an integral portion of the U.S.A., who holds an American passport. He did not meet the age requirement, and he has a green card from the U.S. government. Assume that you are a member of the House Electoral Tribunal where the petition for Brown's ouster is pending. How would you decide the three issues raised against him? Suggested answer. The first and third grounds have no merit, but the second is well taken and, therefore, Brown should be disqualified. 1. Robert Brown is a natural-born citizen of the Philippines. A person born of a Filipino mother and an alien father before January 17, 1973, who thereafter upon reaching the age of majority elect Philippine citizenship, is a citizen of the Philippines. Under Art. 4, SEC. 2. He is also deemed a natural-born citizen. 2. The Constitution requires, among other things, that a candidate for member of the House of Representatives must be at least 25 years of age on the day of the election. As Brown was born on May 15, 1962, he did not become 25 years old until May 15, 1987. Hence on May 11, 1987, when the election was held, he was 4 days short of the required age. 3. The Constitution provides that those who seek either to change their citizenship or to acquire the status of an immigrant of another country during their tenure shall be dealt with by law. The provision cannot apply to Brown for the following reasons. First, Brown is in addition an American citizen and thus has a dual citizenship which is allowed by the Constitution. Cf. Art. 4, Section 4, Second. Brown did not seek to acquire the status of an immigrant, but is an American by birth under the principle of jus soli obtaining in the United States. Third, he did not seek to change his status during his tenure as a public officer. Fourth, the provision of Art. 11, Section 17 is not self-executing but requires an implementing law. Fifth, but above all, the House Electoral Tribunal has no jurisdiction to decide this question since it does not concern the qualification of a member-elect. Dual citizenship. Number 8. In 1989, Zeni Reyes married Bentuluk, a national of the state of Congo. Under the laws of Congo, an alien woman marrying a Congo national automatically acquires Congo citizenship. After her marriage, Zeni resided in Congo and acquired a Congo passport. In 1991, Zeni returned to the Philippines to run for governor of Sorsogon. Was Zeni qualified to run for governor? Suppose instead of entering politics, Zeni just got herself elected as vice president of the Philippine Bulletin, a local newspaper. Was she qualified to hold that position? Suggested answer. (1) Under Section 4, Article 4 of the Constitution, Zeni retained her Filipino citizenship. Since she also became a citizen of Congo, she possesses dual citizenship. Pursuant to Section 40 of the Local Government Code, she is disqualified to run for governor. In addition, if Zeni returned to the Philippines, less than a year immediately before the day of the election, Zeni is not qualified to run for governor of Sorsogon. Under Section 39 of the Local Government Code, a candidate for governor must be a resident in the province where he intends to run at least 1 year immediately preceding the day of the election. By residing in Congo upon her marriage in 1989, Zeni abandoned her residence in the Philippines. This is in accordance with the decision in Cause IVS Court of Appeals, 191 SCRA 229. Alternative answer. No. Zeni was not qualified to run for governor. Under the Constitution, citizens of the Philippines who marry aliens shall retain their citizenship, unless by their act or omission they are deemed, under the law to have renounced it. Sector 4, Art. 4, Constitution. Her residing in Congo and acquiring a Congo passport are indicative of her renunciation of Philippine citizenship, which is a ground for loss of her citizenship which she was supposed to have retained. When she ran for governor of Sorsogon, Zeni was no longer a Philippine citizen and, hence, was disqualified for said position. 2. Although under Section 11, Article 16 of the Constitution, mass media must be wholly owned by Filipino citizens and under Section 2 of the Anti-Dummy Law aliens may not intervene in the management of any nationalized business activity. Zeni may be elected Vice President of the Philippine Bulletin, because she has remained a Filipino citizen. Under Section 4, Article 4 of the Constitution, Filipino citizens who marry aliens retains their citizenship unless by their act or omission they are deemed, under the law, to have renounced it. The acts or omission which will result in loss of citizenship are enumerated in Commonwealth Act No. 63. Zeni is not guilty of any of them. As held in Kawakita vs. United States, 343 US 717. A person who possesses dual citizenship like Zeni may exercise rights of citizenship in both countries, and the use of a passport pertaining to one country does not result in loss of citizenship in the other country. Alternative answer. Neither was Zeni qualified to hold the position of Vice President of Philippine Bulletin. Under the Constitution, the ownership and management of mass media shall be limited to citizens of the Philippines, or to corporation, cooperatives, or associations wholly owned and managed by such citizens. Section 11, Art. 16. Being a non-Philippine citizen, Zeni can. Effect of marriage, Filipino. No. 2. Lily Tay arrived in Manila on one of her regular tours to the Philippines from Taipei. She met Peter Go, a naturalized Filipino citizen. After a whirlwind courtship, Lily and Peter were married at the San Agustin Church. A week after the wedding, Lily Tay petitioned in administrative proceedings before immigration authorities to declare her a Filipino citizen, stating that she had none of the disqualifications provided in the revised naturalization law. The jilted Filipino girlfriend of Peter Go opposed the petition, claiming that Lily Tay was still a minor who had not even celebrated her 21st birthday, who never resided in the Philippines except during her one-week visit as tourist from Taipei during the Chinese New Year, who spoke only Chinese, and who had radical ideas like advocating unification of Taiwan with mainland China. Lily Tay, however, swore that she was renouncing her Chinese allegiance, and while she knew no Filipino customs and traditions as yet, she evinced a sincere desire to learn and embrace them. Would Lily Tay succeed in becoming a Filipino citizen through her marriage to Peter Go? Explain. Suggested answer. Yes, Lily Tay ipso facto became a Philippine citizen upon her marriage to Peter Go, who is a Philippine citizen, provided she possesses none of the disqualifications laid down in Section 4 of the revised naturalization law. According to the ruling in Moya Lim Yao vs. Commissioner of Immigration, 41 SCRA 292. An alien woman who marries a Filipino husband ipso facto becomes a Filipino citizen without having to possess any of the qualifications prescribed in Section 2 of the revised naturalization law, provided she possesses none of the disqualifications set forth in Section 4 of the same law. All of the grounds invoked by the former girlfriend of Peter Go for opposing the petition of Lily Tay, except for the last one, are qualifications, which Lily Tay need not possess. The fact that Lily Tay is advocating the unification of Taiwan with mainland China is not a ground for disqualification under Section 4 of the revised naturalization law. Effect of Oath of Allegiance. TCA, a Filipina medical technologist, left in 1975 to work in ZOZ state. In 1988 she married ODH, a citizen of ZOZ. Pursuant to ZOZ's law, by taking an oath of allegiance, she acquired her husband's citizenship. ODH died in 2001, leaving her financially secured. She returned home in 2002, and sought elective office in 2004 by running for mayor of App, her hometown. Her opponent sought to have her disqualified because of her ZOZ citizenship. She replied that although she acquired ZOZ's citizenship because of marriage, she did not lose her Filipino citizenship. Both her parents, she said, are Filipino citizens. Is TCA qualified to run for mayor? Suggested answer. On the assumption that TCA took an oath of allegiance to ZOZ to acquire the citizenship of her husband, she is not qualified to run for mayor. She did not become a citizen of ZOZ merely by virtue of her marriage, she also took an oath of allegiance to ZOZ. By this act, she lost her Philippine citizenship. Effect of repatriation. No. 3. B. Julio Hortal was born of Filipino parents. Upon reaching the age of majority, he became a naturalized citizen in another country. Later, he reacquired Philippine citizenship. Could Hortal regain his status as natural-born Filipino citizen? Would your answer be the same whether he reacquires his Filipino citizenship by repatriation or by act of Congress? Explain. First alternative answer. Julian Mortal can regain his status as a natural-born citizen by repatriating. Since repatriation involves restoration of a person to citizenship previously lost by expatriation and Julian Mortal was previously a natural-born citizen, in case he repatriates he will be restored to his status as a natural-born citizen. If he reacquired his citizenship by an act of Congress, Julian Hortal will not be a natural-born citizen, since he reacquired his citizenship by legislative naturalization. Second alternative answer. Julian Hortal cannot regain his status as a natural-born citizen by repatriating. He had to perform an act to acquire his citizenship, i.e., repatriation. Under Section 2, Article 4 of the Constitution, natural-born citizens are those who are citizens from birth without having to perform an act to acquire or perfect their citizenship. If he reacquired his citizenship by an act of Congress, Julian Hortal will not be a natural-born citizen since he reacquired his citizenship by legislative naturalization. Effect of repatriation.